of yesterday, and we will try and make up time. We have a busy schedule for this morning. We plan to bring 5 witnesses to the Commission today, injury time and extra time permitting. But we're ready to start, and my colleague Advocate Gue is ready to start with Mr. Raja.
Thank you. Yes, Ms. Gue.
Good morning, Commissioner, members. Mr. Raja is ready to proceed with MST. May I please sit?
Yes.
Thank you.
Mr. Raja, I think it's a new day, so let's take the oath afresh. Do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help me God?
So help me God.
Thank you very much. Yes.
Good morning. Commissioner, before I start with the MST transaction, I just thought if you would allow me to make a correction to one of the answers I had given to Ms. Marcus on one of her questions yesterday on SNS Refinery, if I may. Ms. Marcus asked me whether on the EcoBank, whether the loan or the LC was being serviced. And I answered yes. I'd just like to correct that it was serviced on the first tranche. The second tranche, as I understand, has been partially serviced but not fully settled. So I just wanted to clarify that.
Good morning. Good morning, Mr. Raja. Yeah, just to follow up on the SNS issue. The one question which I was not clear about was on the equity contribution of the company. You mentioned that there was $22 million that Mr. Rasool contributed, and you said the $18 million was for the PIC, meaning, did you mean that there was a total of 40 million of equity, or did you mean that 28 million that the PIC used was used to pay out Mr. the man, Mr. Rasool?
Okay,
yeah. Yes, if you can clarify that, because it's one thing which I'm still not sure there. Yeah.
Okay, the issued share capital of the company would be $40 million. Subsequent to that, there would have been the $40 million would have been an equity subscription. So that subsequent to that, when there was an additional $10 million, that was just a purchase and sale between the shareholders. So it did not alter the share capital of the company. The share capital of the company still remains $40 million.
I see. So in terms of the total project cost, there was that 22, which was in the balance sheet. It was never touched. He contributed that. And then there was the 18 million that the PIC contributed, which was part of the project cost. It was not touched. The only money that he got was the 10 million, which came to buy that 25% stake. Okay,
yes, that would have been the purchase of shares. But right at the outset, as I mentioned, Mr. Rasool had funded the projects through shareholder loans. So when PIC money came in, it had come into the company, would have paid some of that loans, and the balance converted into share capital. But in the end analysis of it, of the first sequence of the transactions, it would have been a $40 million share capital, and that would have remained even up till today. And the 10 million is just a purchase direct between Mr. Rasool and PIC.
And the PIC, yeah. Okay, all right, yeah.
Mr. Raja, am I correct that the overview of impact investing division and roles and responsibility remains the same as you outlined yesterday?
That is true, except for the part of where I was senior fund principal. I'm now executive head of impact investing, but in terms of roles and responsibilities and structure of the division, it remains the same.
In that case, I'm going to ask you to start at paragraph 7 of your statement.
Okay, so if I started paragraph 7, which deals with the origination of the MST transaction. Sometime in June 2015, PIC's Chief Financial Officer, Ms. Matsepo Mora, mentioned to me that someone had inquired about whether we could consider providing funding for mobile buses to be used for inter alia health and education purposes. I indicated that on the face of it, the nature of the project falls within the investment mandate. However, we would require additional information. She indicated she would refer them to the impact investing team, then called developmental investments, and we should see whether it is viable or not.
Sorry, Mr. Roger, just on that, did you subsequently find out who that person was that who had approached them?
Yes, it was the client, Mr. Watkins.
Mr. Watkins, thank you.
On Thursday, the 2nd of July 2015, the CFO forwarded documentation which mobile specialized technology, which I'll refer to as MST, sent to her. On 6th of July 2015, I furnished I forwarded the same email to Ms. Sepati Moichela, an associate principal in the social infrastructure team of the impact investing division.
Just to check something there quickly, is that when you get a transaction, how do you decide where it goes? I mean, whether it's private equity or your division and the other divisions?
Okay, through you, Commissioner. What would happen if a transaction came through to me? I would understand what the criteria is for private equity as well as for other divisions within PIC. If it falls within those divisions, I would send that through to the head of that division. Now, in this particular case, when the transaction was described to me, I had already known that it fits within my division, hence I requested Ms. Moore to send through the proposal through to me. When it comes to me, within my team, I would have different fund principles. I'll have one that would cover energy, one that would cover social infrastructure, that is education, health, and affordable housing. I would have one that covers SMEs, one that covers what we refer to as priority sector, but that covers a broad range of sectors where there's high job creation. So, and then I'll have a person who will deal with economic infrastructure. So when the proposal comes to me, I'll look at the nature of it and I'll forward it to the appropriate person.
So meaning that, okay, the main question is that what is the difference between your division, say, and private equity and SIPs? I mean, what would be the key differences there?
Okay, the key difference, I'm dealing with it predominantly. What the difference is on private equity, it will tend to be your BEE type transactions where there's transfer of ownership from one to another. So it has although it could have impact on the company, it does not have impact on the company's balance sheet. It is just a share transfer transaction between two shareholders. Of course, you could get situations where there is a BE transaction with a subscription of shares where money flows into the company. There's a fresh issue of shares and the proceeds flow into the company. On my side, on the impact investing side, we're dealing here predominantly with a situation where you are investing in startups or in expansions. Now, how we've tried to distinguish between whether it goes into private equity or impact investing is that we say if the majority of the capital required goes into the company to enhance the productive capacity of that company, that would fall on the impact investing side. If the majority of the funds flows into the hands of another shareholder, that would fall in the private equity side. So that would be the distinction.
Yeah, that's clear. Thanks.
Through you, Commissioner, if I can proceed to the overview of MST, which is paragraph 9. MST manufactures and kits buses from corporate social responsibility funds or from government departments and public entities to be used to offer social benefit to society. MST offers a complete service solution incorporating vehicle custom design, manufacturing, operations and maintenance, including the staffing of the mobile, school, healthcare and educational bus units. MST has evolved over time while continually refining its solutions to offer a one-stop shop for all its clients' mobile needs. As a result, MST Group established specialized subsidiaries or divisions to focus on core functions to ensure that comprehensive solutions are on offer. MST Mobile Healthcare and MST Education buses are used to provide healthcare services and education services to children at school. MST provides preventative healthcare which allows for early detection and correction of simple health problems before they become disabling matters. The mobile health buses are fully customized and consist of primary healthcare consultation room, an optometry room, and a dental consultation room. Education buses provide children with exposure to technology and offer career guidance to spearhead the learner's growth path.
Sorry, Mr. Raja, on paragraphs 9 and 10, as you've outlined what MST does, is that knowledge you have of what they do from your due diligence, or is it what they say they do?
There is knowledge from what we know they do during due diligence. Of course, we have also established during due diligence they do other things as well, such as on the HIV testing, as well as registration of contractors or small contractors with NHBRC for CIDB grading as well.
And in that, in your due diligence, how many buses did they actually have in operation doing all of this? Given that the request was for building more buses, yes. So one would assume if they need to build more buses, they've got some in operation, given what you've said here. Just to get an idea of the scale of what is the current, at this point in time, what was the current functioning and what was the add-on that was required from the PIC?
Through you, Commissioner, I think it's in somewhere around 25, if I'm not mistaken. We can get the exact numbers. And then the funding for the PIC was for an additional 7 buses.
I think let's get the exact number that were operational at this point in time, so that one can, because it's a national operation, it's not although it's based in Western Cape, it's a national operation, so we know how many that is. And when you do come to that point, please just indicate why the initial request and the documentation was for 14 buses, but the actual approval was for 7. How did it go from 14 to 7? And then obviously we would want to know how many actually were made.
Okay.
I'm tempted to ask where this is happening.
Western Cape.
Is it only in the Western Cape? Because I wish I could see some in the Eastern Cape.
Chair, I understand it's beyond the Eastern Cape. I think it's also in Mpumalanga, but I think a lot of the detail, I'm sure Ms. Constance will come in, will actually even provide in terms of the number of buses, as well as explaining the 14 and the 7 as well.
Just want to check their business. Do they manufacture the buses and then hand them over to some people to operate them, or they manufacture and they operate those services, you know?
Through your Commissioner, both. So it's one way you would manufacture and you would sell it off completely. The other one would be you'd manufacture and you'll operate it as well. So it's the both services. Commissioner, if I can move to paragraph 11. In June 2015, MST had applied for a loan of 45 million. Following discussions between PIC's investment team and MST, a scoping report was tabled on 16 July for consideration to the Portfolio Management Committee. The Portfolio Management Committee approved for the transaction to proceed to due diligence. Upon completion of the due diligence, the investment team presented the investment to PMC on 23rd November 2015, where PMC approved a term loan of 30 million plus 25% equity at a nominal amount of 25 Rand.
Just to check, on paragraph 9, you mentioned that they used to operate by getting money from CSI funds, government funds. So were they trying to be a profit-making company, or were they non-profit before?
Through you, Commissioner, it has always been a profit-making company. When the investment team informed MST of the conditions of approval by PMC, MST was not willing to offer equity to PIC unless it was offered based on a company value of 103 million Rand. This amount is to the best of my recollection, but I remember it being 103 million Rand. When the investment team mentioned this value to me, I refused because it meant PIC must pay for the value created as a result of funds provided by the PIC. So there's an established principle in PIC that where we're putting in money into a company, and because valuations are based on a forward-looking picture, if we're putting in the money and that is creating the profits, we cannot base a value on that. The value must be based on excluding our funds, and hence I had refused for the transaction to be done on the basis of 103 million Rand valuation. At a point in time, I was traveling to Cape Town, and the client became aware of my travel arrangements and requested a meeting with me whilst I was in Cape Town. Prior to my return to Johannesburg, I met with the client at Cape Town International Airport. This was the first time I had ever met any representative from MST, and that's largely because I do not get involved in the due diligence process.
Sorry, do you know, do you know why the client contacted you specifically, and why didn't they contact the team rather?
I would imagine that because it dealt with an issue of the critical part of the terms of the funding, they would have thought that I would probably be in a more senior position to maybe make a determination as to whether I'd be able to agree to another structure. And I'm sure maybe the team had mentioned to them that it was I who had refused the valuation of the 103 million. So at the meeting, I explained to the client that because the client didn't want to give us shareholding unless we paid at market price. So I explained to the client that PIC receives a mandate from its clients. The mandate stipulates the return expectations, and therefore a conventional term loan would not enable PIC to achieve its return. The client agreed that we could explore alternative structures so as to meet mandate requirements. On 8th of June 2016, the PMC granted approval for a revised proposal comprising a debt facility of 21 million Rand, bearing commercial rates plus a 5% profit share. I'd just like to add at this point in time, you'll notice the amount had come down from 30 million to 21 million, and that was at the client's request. Because in the meantime, the client had also been approaching Mercedes-Benz for finance. Following the approval, legal agreements were signed, and after fulfillment of the suspensive conditions, funds were disbursed on 6 July 2017 into the bank account of MST. With regards to my involvement in the MST deal, with regards to this particular transaction, I had no direct involvement in the transaction other than ascertaining the nature of the transaction did indeed fit the PIC mandate. Upon receipt of email and attachment sent to me on, if I can correct that, it's 2nd of July 2015 by Ms. Matsepo Mora, I had forwarded the same email 2 business days later to Ms. Sepati Moichela, an associate principal in the Impact Investing Division. From this point onwards, the investment team ran with the project, and at each point in the investment process where submissions need to be made to the relevant PIC committees, I would review the document compiled by the investment team and sign these for submission. The conditions precedent is stated in page 81 of the term sheet.
Question? Do you know how Ms. Moret got in contact with the MST, the company, the initial contacts and all that?
No, I don't. But all I know is that she had told me that she had met some people who were looking at funding for this kind of initiative, and she had described it to me, and based on the description, I felt it met the mandate, and all I said is get them to send through the proposal to me. The conditions precedent is stated on page 81 of the term loan facility agreement concluded between MST and PIC, and this was done on behalf of the Unemployment Insurance Fund. The following are paraphrasing of the conditions precedent: providing certified founding documents, providing certified copy of shareholders register, providing relevant corporate authorization and approvals to give effect to the loan, including provision of specimen signatures, confirmation of borrowing authority, absence of defaults, and various representations and warranties. All other related agreements are correct, complete, and accurate, and in full force and effect, and there is full compliance with financial covenants. No material adverse change has occurred, financial or otherwise. Various documents evidencing pledge, cession, guarantees, and subordination of debts in favor of PIC were to be duly executed and become unconditional and in full force and effect. Certified copy of the related annual financial statements, certified copy of the consolidated annual budget, provision of a legal opinion regarding incorporation capacity and due authorization by the borrower. Lending approvals must have become unconditional. Auditors confirming liabilities, shareholder loans, percentages and trading history. The provision of a 5-year business plan, and providing tax clearance certificates. These conditions were fulfilled.
Sorry, can I ask you, did MST provide audited financial statements certified?
Look, through your Commissioner, yes, MST had provided audited financial statements as at 30th of June 2015. But I would come later to why I feel that perhaps prior to disbursement we should have had 30th June 2016. These conditions were fulfilled prior to disbursement taking place. It is worth pointing out the following. The special notarial bond is incapable of being registered until the buses have been constructed as specific identifiable information about the assets must be in place before a special notarial bond is registered. Technically, the provision of 30th June 2015 audited financial statements would discharge the condition of providing annual financial statements. However, in retrospect, PIC should have demanded the provision of 30th June 2016 audited financial statements prior to disbursement. I'd like to mention at this point that what the team had done in the absence of because those financial statements as of 30th June 2016 was not in place, the team had obtained the management accounts and interrogated the numbers to test for their integrity, but there was no audited financial statements at 30th June 2016.
Have those financial statements subsequently been provided, and obviously in the subsequent years been provided to PIC?
Through you, Commissioner, that has been a problem in obtaining these financial statements. They did, however, send through some financial statements in for 2017 in January of this year. However, we have to point out that whilst it may meet the requirements of the Companies Act in terms of in the Companies Act, there's provisions depending on the public interest score. You could have financial statements that are independently reviewed. You could have financial statements that are audited. What seemingly is provided is what is independently reviewed. Whilst it might meet with the requirements of the Companies Act, it does not meet the requirements of the PIC legal agreements, which is to provide audited financial statement regardless of what your public interest score is.
Yeah, just a couple of questions on this company. You were giving them a loan of 21 million. Two questions. Was this the normal size of a typical transaction within your division? And in terms of growth, I mean, was this company sort of promising quite some growth?
Through you, Commissioner, in terms of size, we would typically do transactions above 50 million rand, but what we do is that we haven't had it cast in stone. Usually, sometimes when we do go to the committees implore on us to, where we find transactions that have good social impact, we should look at transactions of smaller amounts. But on my division, I think the smallest transaction we had ever done was a transaction for 5 million rand. I think this would have been the next. No, then there was one for 20 million, and I think this is the third smallest transaction we had done in the unit. Mr. Lidiga, if you can just repeat your second question.
Just in terms of growth of this business, I mean, was that quite promising or what? Yeah.
I think on our side, we looked at it from the point of view, if we take how BEE has evolved over time, and if we look at the compliance with it, and that you'd find that you can see clearly there's more and more commitment to BEE. So I think in terms of how much of money was going to flow from whether it was CSI budgets or enterprise development budgets, we saw that as growth. But I think importantly, yeah, what we looked at was the benefit that this was offering to particularly youth in the country, which was a strong reason why even later we even considered providing funding from our corporate side, not from client funds, in terms of the CSI, because we thought it was doing good to society.
And besides the money you put in this company, what is your typical check size? What is your typical check size, average check size?
That would be difficult for me to, but we can provide that information. We can look at the transaction and we'll give you maybe the average and we'll give it to you in buckets. We can provide that to the Commission.
Yes, please. Yes, please.
Sorry, Mr. Raja. I just wanted to find out, was the forecasted financials a realistic forecast of the projected revenue growth? And can you also provide us with the same, if there were?
Through your Commissioner, at the time we thought it's realistic. What has since happened, the client is making allegations that as a result of all the negative publicity surrounded the MST transaction, that the PIC is the responsible party for the decline in the revenues, which we refute. But we will provide the historical financial statements. The present status of the investment, as the Commission may be aware, this investment has received widespread adverse media coverage over the past 18 months. I think you'd see a lot of the stories relating to the CEO and the girlfriend story, but I think that was the publicity that was out there. MST is in default in terms...
Yeah. Just to be clear, so the girlfriend story is about the 5 million which was in the CSI fund, and this 21 million is a separate matter because this is the company. Is that correct?
Factually speaking, the involvement of Ms. Pretty Low was on the 5 million. But if you take media coverage focused mainly on the 21 million. That was what's in the media. So if you look at media articles, it's talking about the 21 million rather than the 5 million. But factually speaking, the story should have been on 5 million, not on the 21 million.
Did Ms. Low participate in the raising of the capital on the 21 million?
Through you, Commissioner. May I proceed, Commissioner? Through you, Commissioner, no, in fact, when the 21 million rand transaction was done, we didn't even know of the existence of Ms. Pretty Low. That we had met with her, I think it was in somewhere around in October 2017, if I'm not mistaken.
So no one got transaction fees in this one?
Not to my knowledge, Commissioner. Maybe the amount was too small.
I'm still interested in this thing. MST, is it only operational in the Western Cape or is it a national initiative?
It's not national, but it is in a few provinces. It's not, not in a Western Cape, but it is in a few provinces that the vehicle travels.
Yeah, I'm just worried about, I see you say it gets funding from CSR funds or from government.
Most
That's
of
why
it.
I'm asking.
From my understanding, most of it is from government or CSI or public entities. Those would be the target market. So even if you take, like, for example, NHBRC is a public entity. It's related to government. So that's where the focus is. But I think my colleague, when she presents, I think can give you more information on that.
I just don't want my province discriminated against.
Sorry, Commissioner, maybe the roads needs to be fixed first. Commissioner, I think I'm on paragraph 24. MST is in default in terms of its financial obligations or servicing of the loan. Its defense is that the adverse media coverage has done immense damage to its reputation, and consequently it is finding difficulty securing additional business. On 8 May 2018, MST wrote to PIC accusing PIC of being complicit by its silence to the media allegations of wrongdoing on its part, and this negative publicity was affecting the finances of the company and causing delay in the issuance of its annual financial statements by its auditors. This is based on articles carried by City Press in September 2017 and in May 2018. I'd just like to also mention that the Commissioner, that the client is saying that hence it had changed its name from MST to I forget the name of what's its recent name. But if we look at the issue with regards to the annual financial statements, Commissioner, is that I don't think that what is said is true. It's because of us. I know that the auditors are reluctant to sign off because of the coverage in the media, but some of the part of that financial statements was before these stories came out in the media, so there can be no excuse for non-issuance, for example, of 30th June 2016 financial statements. MST has applied to PIC to restructure its facility. The proposal was tabled to PMC unlisted investments, but was rejected primarily because the PIC has experienced great difficulty in obtaining audited financial statements for the years 30th June 2016 to 30th June 2018. However, more importantly, there is a lack of cooperation by MST in providing information on the buses to enable the registration of special notarial bond. In addition, there is preliminary evidence to suggest that PIC funds were not wholly and exclusively used for the construction of new buses. I think a lot of that detail would come out from a post-investment team's testimony. PMC Unlisted Investment has approved that the restructure proposal not be considered. An MST must be issued with a default letter, and in the event that the default is not remedied within the agreed period, PIC should exercise its rights in terms of the agreements concluded. I'd just like to mention that on this particular case, we have issued that letter. It has not been remedied, and a demand has been made for the acceleration of the entire loan amount that the lawyers have issued. Chair, in conclusion, I mean, I'd just like to say, I mean, this year we see it as a sad state, given that this project, if we look at what it's intended to do, I think it's a very good project that can improve and touch the lives of many South Africans, particularly youth, and that's the sad thing about where we are today. Thank you, Chair.
Mr. Raja, can I ask a couple of questions? Because I think that, and obviously it'll be also covered in the next witness, but your preliminary evidence to suggest that the PIC funds were not wholly and exclusively used for the construction of new buses, from the documentation that I've read, it looks like there were no buses manufactured at all, and that there were different reasons given, including rekitting of some buses, but the chassis numbers couldn't be traced, and then different arguments as to why it was required. The first would be to, I mean, as you indicated, they got a loan from, or funding from Mercedes, and then the argument given is that that funding would be to enable MST to explore other chassis suppliers without being limited to Mercedes-Benz. So you borrow money from Mercedes and they're not bound by their chassis, so you borrow money from the PIC in order to not be bound. It just does not make sense in terms of the approvals. And then in the minutes of the meeting of the PMC Unlisted, which was in July 2015, it says the reason was to meet its order book. So the loan was given to meet its order book in one set of documents, and then in another set of documents it was to enable it to explore other chassis suppliers, and in the end there's no bus built. So what happened to the 21 million altogether? And then in your annexure D, is this normal for the PIC to precondition loans? The committee emphasized that MST should improve its BE level through incorporating a female BE group in the shareholding and a female at operational level. Would that be standard procedure that you would say, to get our loan, this is what you need to do, and therefore fundamentally alter the composition, nature, accountability, competencies of a company? I'm not disagreeing with the question of empowerment, but I think that if I was running a company and I had a determination that this would alter my functioning, and my competencies as to have a precondition met of this nature, how do you take accountability? How do you make the entity accountable if you're imposing those kind of conditions? And is it standard to impose them?
Through you, Commissioner, I think, Ms. Marcus, the question with regards to the application of the funding, I agree that it's when we look at what is in the appraisal document or the approval, what is carried forward into the legal agreements state new buses. And I think that has become the source of disagreement between the client and ourselves, because the client, it would seem, based on if we review the documents, that the team would have spoken to them about not only new buses, but when it came to the agreements are concluded on the basis of strictly new buses. And so on the legal side, that's what they are sticking to, is that you've signed that it will be new buses. But the client is contending that was not the discussions, notwithstanding that they had signed on new buses, and that's the where there's a big disagreement on. So yeah, I think.
But surely, as yourselves, you've agreed to it on the basis of the legal documentation.
Yes, we agreed on the basis.
So
we are pursuing on the basis of the legal agreement. So that is what was signed, and I think it's fair to say that if you're signing the legal agreements, you have reviewed it, you've contributed. It was not a quick process. So you would have applied your mind to it. So we are sticking on the basis that it's for new buses. And I think that, speak under correction, I think that the team was only able to verify one. They had provided 8, that they sent the team around in circles, many times traveling. I know they had even traveled into Mpumalanga to even look at buses, but the client in the initial stages was so convincing that at some point I even doubted my own team. But as you go on, you can see that there's not a willingness to open up and be transparent, because it's a case of we can always look at how we can come to an amicable arrangement. But right now, it's very difficult to get information from them. And hence, we've taken the decision to call up the loan and exercise our rights. And we've rejected the 3 proposals that they made to us, because the 3 proposals made to us is to inject more capital into the business, and we're not prepared to inject more capital into the business.
can I take you to the UIF mandate document of July 2015. And there you've got a shareholding for MST, which relates to paragraph 3. Can you just tell us a little bit about that shareholding? And when you had a conditions precedent, you said that, or it had to provide that the tax affairs were in order. Would that be as MST or also as the individual shareholders? And how would you assess the question of the shareholding in that sense? I mean, is this what you would have examined? Both 3, because 3 relates the names of the organizations or trusts, and I'm assuming the 3 in the paragraph gives the names relating to it. Can you just talk to that a little bit?
Sorry, Commissioner, can you just tell him which annexure you're looking at?
That's a very good question, because I had it as a separate sheet, and I'm not sure it came in the annexures, but it is the 16th of July Social Infrastructure 2015 UIF mandate, and it gives a synopsis of the salient features of the project. It doesn't come under a tab, it came separately.
Well, Chair, through you, Commissioner, I think I would remember there was we've painted the picture of the shareholdings,
Yes.
which have been would have been through companies and trusts. So there, where we had examined the shareholding, about 60% of the shareholding was related to the main sponsor there, Mr. Fernando Acafrao and his family, and then there are two other, I think, shareholders, one of which is Mr. Reggie Kukama and Mr. Jonathan Bear, through their companies, are in the shareholding as well. That was examined at the time of the due diligence.
And would these shareholders have been informed of the state of affairs of MST as we have it now?
I cannot confirm that now, but we can confirm post the meeting. I'm not aware of that.
I would think that's quite important because I mean it's again I'm not able to see who is who in relation to the companies. But you've got Yaitsho Investments, which is 20%, Plumari Family Trust 10%, Rapid Relief Trading 5%, FA Children Trust, which I'm assuming is Fernando Acafrao, 60%, and Buff Shelf 57 Trust 5%.
Yes.
So I'm assuming that the people relate to that, and
Yes.
I would want to know that all of the tax matters related to the individuals as well as MST and those companies are also in order.
We will confirm that, but what I can say is that at least at company level we would have checked the tax affairs of the company, but I'll confirm whether that was extended to shareholders as well.
And whether those shareholders are all informed and are fully aware of the state of affairs of MST as it stands today, the question of inability to get audited financial statements and the prospects of its business continuing in a profitable manner going forward.
We will do that, Commissioner. And the question related to on the imposition of certain requirements insofar as introducing female at shareholding level and so forth. What would normally happen, if I can explain to the committee, is that you'll have the deal team which will do the due diligence on the commercial side and the risk. Then you have an ESG team, legal team, and risk team. So the ESG team, independently of that, would come up with their own recommendations. And they would put in recommendations in terms of trying to improve, as an example, the BBB status of the company. Normally that won't be a condition precedent, but it will be an undertaking, and usually they would give them between 18 months and 24 months within which to achieve that. So that is what the ESG recommendations that are tabled at the approval committee, and if the committee approves of that, that would become the condition. I do take Ms. Marcus' point in terms of imposition of certain requirements could end up, well, you could put yourself on the back foot, because if things go wrong, they'll probably say it's because of you. And I take that point.
In that circumstance, as you've made a recommendation, as indicated in 10.9, emphasize the MST should improve its BE level through incorporating a female BE group in the shareholding and a female at operational level. In those circumstances, does the PIC ever make recommendations of names, or does it leave it to the entities?
Through Commissioner, we won't make a recommendation of names. We would leave it to the entity, but on occasions it might be subject to us agreeing to who those people or individuals are. But we would never make that recommendation.
Does the PIC have someone on the board of the company?
In this particular instance, because it's a loan, it doesn't give us that right to appoint a board member. Yeah. But if we were in shareholding, we'd probably have the right to appoint usually one or two people.
My worry is that it seems that there are times when the PIC struggles to get the financials, of companies. It was the Mozambique company, which is a bit different because it's a different country in many ways, but we still need those. But here too, you are battling to find the financials. What causes that? Companies must do financials. And why can't they do them and send them to the PIC?
Look, through your Commissioner, in this particular instance, firstly, I believe that for 30th of June 2016, the company has no reason not to have provided that. I could understand that maybe with all the negative publicity that surrounded the investment, that the auditors probably are very cautious and taking the view that they don't want to sign. I'm inclined to believe that that might be the case, but definitely not for June 2016. What has been provided to us now is a watered-down version of an audit because the Companies Act allows for it. But our agreements is very specific. We want audited financial statements that is applicable to the normal companies that are audited, and that has not been forthcoming. I think the client is doing this to pacify us in the meantime of giving us a watered-down version of financial statements. We need a higher degree of assurance in terms of a full audit.
And given what has come to pass, what has gone down with this investment, is there something that you think you could have done better in terms of the investment process on this company?
Through you, Commissioner, I think, look, I don't think that we could have done more. I think, sometimes when you get involved in these investments, only with retrospect, you begin to understand the team better. But at that point in time, we were quite confident. If we looked at some of the let's call it the non-active shareholders, one of them at least would have given us a lot of comfort in there, because we know the person as a solid business person.
What is his name?
Well, in here it's Mr. Jonathan Bear.
Mm-hmm. Mm-hmm. Yeah. And so, do you check the track record of the businesses? Like somebody comes and say, "This is my company." Do you check if they've done more companies before, the relationships with shareholders, creditors, those kind of issues?
Through your Commissioner, yes, we would have done so, and if there was any adverse finding, like for example, we would do the normal credit checks as well, the CIPC checks in terms of what other businesses they are involved in, because you've got to ascertain whether there's also risks of shifting of profits. So those are done during the due diligence phase. Quite a bit of work is done on that.
Perhaps just one additional point, again referring to that UIF mandate. Part of the information provided is in terms of social impact, and it says approximately 224 permanent jobs will be created post-construction and 300 direct and indirect during construction. So there was no ambiguity that this was to construct buses.
Yes. It would have been new buses.
It would be new buses for construction.
It could not have been just kitting.
Could not have been re-kitting with that kind of information. Yes. And then secondly, if I could ask you to please check whether, given that you have mentioned his name specifically, Jonathan Bear, as a shareholder, whether he is aware of the state of affairs of MST.
We will do that.
Commissioner, that concludes the testimony of Mr. Raja. May I request a 10-minute adjournment to allow Ms. Matsikanda to take the stand.
Yes, before we adjourn, thank you very much, Mr. Raja, once again for coming to testify before us. Thank you so much for the information.
Thank you, Commissioner.
Okay, that doesn't mean it's the end of you. You might come back at some other time. We'll adjourn until 11:15. Ms. Matsikanda, are you the next witness?
Yes, Commissioner.
And I'm sure from yesterday you still remember about the oath, taking the prescribed oath?
Yes, Commissioner.
No objection to do it again?
No
Can
objection.
you just stand up, and do you swear that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? Raise your right hand and say, so help me God.
So help me God.
Thank you so much.
Thank you, Commissioner. Ms. Matsikanda gave an overview of the PMV department and its role yesterday. So if Commissioner allows me, Ms. Matsikanda is going to start at paragraph 11 of her statement.
Handing over of the MST transaction.
That's correct.
Yes, thank you.
On the 21st of June 2017, the PMV department and other relevant departments attended a handover meeting in respect of the MST transaction, which was convened by the Isibaya operations team. The PMV department was represented by Mr. Leseho Mutupi in his capacity as a PMV associate. The purpose of the handover was for the transaction team, also known as the deal makers, involved in the MST transaction, to brief the representatives thereof, amongst others, PMV, ESG, finance, and Isibaya operations of the transaction and the investment thesis. Following the meeting, a disbursement memo prepared by Isibaya operations was submitted to me for signature. Based on the disbursement memo, together with supporting documentation, including the transaction agreement, I gathered the following. A funding of 21 million in favor of MST had been approved for the manufacture of 7 buses, which had been ordered by 2 customers of MST. An extract of the minutes and the resolution of the meeting of the PMC, whereat the MST funding was approved, are attached as Annexures 1A and 1B respectively. The funding would enable MST to explore other chassis suppliers without being limited to Mercedes-Benz.
Sorry, can I just ask you in relation to that? It is for the manufacture of 7 buses, but in the original proposal it was 14 buses. How did this amount of money go from 14 to 7? And in your examination post the investment, were you able to identify how many buses of this nature were in the fleet that was being operated or had in fact been manufactured by MST, so that we would know the proportion of 7 or 14 in relation to the whole of what MST was about? And then in terms of your 12.3, to explore chassis suppliers without being limited to Mercedes, my understanding from what was said earlier was that the funding was reduced from the 45 million, 30 million down to 21 million precisely because there was a funding from Mercedes that had been obtained by MST. So why would this be a rationale for the lending, that you would want alternative suppliers when they've just obtained exactly that role in the funding through Mercedes? You know, it seems to be contradictory as to what the purpose of the money was in the different times. It was the question of saying it was for expanding the business, it was for the question of, you know, to enable MST to explore other chassis suppliers, but it was also for the ability to expand the order book, same money being used in different, with different objectives, but it's the same money. If you could just clarify some of that for us.
Thank you, Commissioner. In my understanding, the initial 14 buses that are in the appraisal report would have included 7 whose chassis had been or would be acquired from Mercedes. But from that appraisal report, it seemed there was a challenge in having only Mercedes as the funder or supplier of the chassis, and hence they requested funding which would enable them to explore the chassis procurement from any other supplier without being limited necessarily to Mercedes-Benz. The actual number that was then funded, being 7 buses, could have been procured from Mercedes or any other supplier, but it was essentially meant to procure 7 new buses. Hence, the funding would have moved from 30 million to the 21. So the 21 would involve 7 new chassis and the body as well, which would then become what is the client is now referring to the kitting out, a portion of the funding. So from the resolution, you will see that initially it says that the security will be split from between Mercedes and the PIC. So that would have been, if the 14, the application for 14 had gone through as 14, they could have procured the chassis still from Mercedes and split it with PIC in terms of the security package. However, our 7 is what was concluded and signed on in the transaction agreements, and that is what we pursued to verify in the facts that I provide hereafter. As security for the funding, amongst others, the PIC would register a special notarial bond over the bus units, as well as a general notarial bond over movable assets acquired from the proceeds of the funding. The term loan facility agreement, which I refer to as the agreement, and the conditions precedent satisfaction letter had been signed. I attach a copy of the agreement as Annexure 2. In terms of the agreement, the borrower is required to, amongst others, apply all amounts borrowed by it under the agreement for the purposes of designing, constructing, assembling, operating, and leasing of bus units as per clause 4.1. The purpose of the borrower would also be submit to the PIC audited financial statements by no later than a period 90 days after its financial year end. On 29 June 2017, I signed the disbursement memo on the basis of the documentation that was provided to me, as well as an email from Mr. Matupi, which I attach here to as Annexure 3.
Thank you. If we could just go to 12.4. The registration of your SNB, that would require certain compliance to have been done. For instance, the actual manufacture of the buses prior to registration?
Yes, Commissioner. So the special notarial bond would entail us satisfying ourselves that there are 7 buses that actually exist and are identifiable, and the mechanism of identifying them would be the registration documents, which would give us a vehicle identification number, which is referred to in the statement as a VIN number, as well as further to that having physical sight of those buses before we can proceed to have our lawyers lodge and register the SNB.
Has that ever been registered?
No.
So that there hasn't ever been compliance with the requirements for registration?
No, Commissioner. We have over a long period tried to verify through at least 4 site visits, but we've only been able to match 1 bus of the 7 listed in the documents provided, and the rest that we have been given security documents for referred to registration dates of buses that were manufactured from as far back as 2011. Which is what we've established, that there are no new buses that were actually manufactured from the funding, but it's taken a process of at least 4 or 5 site visits to have ourselves confident that there is actually no new buses that were manufactured.
Do you know what actually happened to the money?
We did request a breakdown of the usage of funds at some point, and that breakdown is one of the annexures, which refers to various components of a bus, such as electricals, plumbing, hydraulic systems, air conditioning, and only 2 chassis of that list is indicated as having procured from the 21 million. And based on that breakdown, it is where we then establish that there's a misalignment in the application of funds, because it's unlikely that PIC would have approved funding for the components of the body of the bus without the chassis, because that would then contradict the reason or the requirement for a special notarial bond. So the client, as Mr. Raj alluded to earlier, is disputing that the original agreement was that they would acquire new buses in the first place. They have said that discussions right from inception were that they would use the funding to kit out. And on the basis of that, that's why we have now taken the matter to external legal counsel. Most of this detail is covered in the statement, which I'll go through still. But that essentially is the nature of the transaction as it stands. Okay. Introduction to investee company. PMV established first contact with the client within the month of disbursement, which was on the 31st of July 2017, to request an introductory meeting and site visit and security verification. There were various requests to confirm a meeting date from July 2017, and the client was only able to confirm this visit for the 1st of November 2017 at the client's Johannesburg premises in Lenbro Park.
Sorry, can we just stay with that a second, and it may be within your area or not. Would a situation which takes that amount of time to enable a site visit not have raised concerns about why would this not be something, if you wanting to get a loan, that you're not available the next day?
Chair, the client indicated at that time they were busy with the procurement of the buses and the manufacture as it is provided. There were requests for update as to where are we in terms of manufacturing these buses, how many have actually been manufactured, how many have you taken delivery of, and they confirmed at some point, which I referred to, that they had indeed received at that point 6 of the 7 buses, and therefore in terms of the verification, what we understand is the manufacturing process takes about 3 to 4 months. So us going to the site visit in November would have been exactly 4 months after disbursement, and that at that point was a reasonable time still to make a first attempt to physically verify. But in terms of introducing ourselves to the client as now the custodians of the investment, the effort started in July to get a meeting, but was only confirmed for November. Steps taken in monitoring the investee company. Security verification and registration. On the 6th of September 2017, Mr. Matupi sent an email to the client requesting an update on the number of buses that had been manufactured and delivered to MST, as well as an operational update as per the agreement. A copy of Mr. Matupi's email, as well as subsequent correspondence, are attached as Annexure 4. The following day, the client responded that 6 of the 7 buses had indeed been delivered and that the 7th bus would be delivered in the following week. On October 2017, Mr. Matupi wrote an email to the client asking for the particulars of the buses to be registered under a special notarial bond. These particulars were then sent on the 30th of October 2017, prior to the first meeting. The client provided the list which contained VIN numbers of 7 vehicles, which are also in Annexure 4. At the meeting on the 1st of November 2017, a bus tour was conducted. However, the client informed us that the buses on site were not the PIC-funded buses, as those had already been deployed to service the customer contracts in different parts of the country, including Cape Town. Following this meeting, a new list of VIN numbers was provided by MST to members of the transaction team, who in turn forwarded by email such list to Mr. Matupi on 13 March 2018. A copy of the email to Mr. Matupi is attached as Annexure 5. It is to be noted that the contents of this list differ from those contained in the list that was provided in October 2017. The second attempt by PMV to physically verify the list of buses that was recently provided was on 15 March 2018. This was at a meeting and site visit with MST management in Cape Town. The PMV department was represented by myself and Mr. Mutupi. The purpose of the meeting was to, amongst others, discuss performance and conclude the security package verification. At that meeting, we only managed to verify one bus from the 7 VIN numbers provided by the client, and this bus had NHBRC branding. I refer to Annexure 5 for that. At the same meeting, the client's financial position was discussed, and based on the existing contracts and management accounts at the time, there were areas of concern regarding MST's ability to service the debt. However, based on the pipeline of contracts considered at the meeting, it seemed the client would be in a position to service their first installment, which was due on the 6th of July 2018. This was subsequently confirmed by the report sent by the client dated 23 April 2018. A copy of the email is attached as Annexure 6.
Sorry, Ms. Matsikane, what did you conclude? What did you think at that meeting when you were not able to verify anyone but one bus?
Commissioner, at that time, the client indicated they were not able to recall all buses to have all 7 stationary for our verification purposes. But what was on site and what was on our list is what we could verify. So of the 7, we only saw 1, and the rest, they said, were operational. Hence, we couldn't have seen all 7 at the time.
Sorry, I might have missed it. Did you get an explanation as to why there were 2 separate lists and different?
I can't remember what the explanation at this point was. But it then is apparent even after that the list kept changing. So even the final list which we have today is different from the first 2. And this is what we are establishing as that there is actually no specific PIC security. And what we've been given is what they have in stock from what they procured a very long time ago. After the Cape Town meeting, Mr. Mutupi conducted another inspection visit on 23 March 2018 at the Johannesburg offices. Between April and June 2018, various correspondence continued to take place between PMV, the transaction team, and the client to clarify the security package. On 13 April 2018, Mr. Mutupi sent an email to the client and amongst others raised the following findings from the vehicle inspection efforts at the Cape Town and Johannesburg offices. As opposed to 5 buses, only 4 being used for the purposes of the RTIA project were identified. And as opposed to 2 buses, only 1 bus being used for the purpose of the NHBRC project was identified. In the same email, Mr. Mutupi requested the client to provide an explanation as to why one of the buses is being refurbished, whilst MST is required to manufacture new buses from the facility and provide information on the exact buses that were manufactured utilizing the facility, including VIN numbers, engine numbers, and registration documents. That is also contained in Annexure 5. On 7 May 2018, and after various correspondence from the transaction team and Mr. Mutupi, I addressed an email to the client regarding their non-compliance with the agreement as it relates to, amongst others, the requirement to register the special notarial bond and the consequences of such non-compliance. In their response, on 8 May, MST disputed non-compliance with the agreement. A copy of the email is attached and marked Annexure 7. On 31 May and 1 June 2018, the client was requested to provide a breakdown of how the funds were utilized. From the client's submission, it was discovered that only 2 chassis were purchased and the balance of funds were applied towards various internal fittings for 7 buses. Copies of those emails and the submission is attached and marked Annexure 8A and 8B. In light of the client's submission, we convened a meeting with the client for the 12th and 13th of July in Cape Town, where, amongst others, we sought to ascertain the reasons for the misalignment in the application of funds to identify buses in respect of which the funds were utilized, and to discuss the default on payment of the first installment, which was due on 6 July. In relation to the asset verification exercise, we were shown some buses that were on the premises. Of those buses, none appeared to be new, and this was subsequently evidenced by registration documents that the client sent later that day. A copy of the email and attachments are attached here too and marked Annexure 9. During the meeting, we requested a final asset list to ascertain the extent to which our loan security could be enhanced further in the circumstances. The asset list provided showed a fleet of 27 vehicles reported to be on MST's balance sheet, and of only 6 of these were unencumbered buses. A copy of that asset list is attached and marked Annexure 10. From the period after disbursement up to July 2018, PMV and the transaction team had been corresponding with TGR attorneys who were mandated to register the security package. And TGR attorneys had been requesting the asset list on various dates, and PMV would provide update on the status of verification. During November 2018, our internal legal proposed that we send a list of 3 other law firms to the client to consider contracting with one of them for the purposes of registering a special notarial bond on the unencumbered buses. The list was forwarded to the client by Mr. Mutupi on 22nd November 2018, and copies of relevant correspondence are attached as Annex J11. The client responded on 11 December, indicating that the directors of the company were not willing to incur any further costs until they afforded an opportunity to meet with, quote-unquote, key decision makers within the PIC. Compliance reporting undertakings. From December 2017 to date, various emails have been sent to the client requesting audited financial statements from 2016 up to 2018. The client has been committing to providing the requested information but has not delivered on any of those dates. To date, the client has provided different reasons why they could not submit the audited financial statements. The copies of the relevant emails are attached here to marked Annex 12.
Sorry, can I just stop you? Can I take you back to paragraph 15.18? Did the client, do you know who the clients were talking about when they said they wanted an opportunity to speak with the key decision makers? Do you know who they were talking about there?
I think from this email we established they would have wanted to meet with the executive head of impact investing and or his senior. But we did respond to this to reiterate that there is no key individual that is able to make a decision about any client's requests in isolation without taking such requests to a committee. And therefore we did notify them that in whether or not they were to meet the key executives, we would be the first place, in the first place, the team that would assess whether that request or whether any of their representations are necessary to take to a committee for approval. Point 16.2, it is to be observed that the client has reported that there are challenges in getting their auditors to sign off the statements, as the auditors have expressed unwillingness to sign the audited financial statements on the back of perceived reputational risk of MST as a result of their association with PIC. However, it appeared from their correspondence with their auditors that the auditors were unable to finalize the audit on the basis of a possible reportable irregularity. That is also contained in Annexure 12. The failure to submit the audited financial statement has impeded our ability to assess the financial position of the client in full, as we cannot place reliance on the management accounts. Debt servicing. The MST loan facility has a tenure of 7 years with biannual repayments due in July and January of each year. The client has failed to repay the first and second installments on the loan due on 6 July 2018 and 6 January 2019 respectively. As mentioned above, a meeting was held with the client during March, being 3 months prior to the installment due date, to determine, amongst other things, whether the client was in a financial position to start servicing the loan. Another meeting was convened on 12 July 2018 to discuss the default on payment, non-compliance with reporting undertakings, and failure to register the special notarial bond. The MST management team indicated that they could only afford 420,000 of the 2,243,238 rands and 41 cents due to the PIC. The team agreed to the part payment and requested MST to submit a debt restructuring proposal in relation to the balance. This 420,000 was paid on the 13th of July 2018. At the same meeting, the client further requested a repayment moratorium for a period of 6 months. In order to enable us to consider these proposals, we requested MST to provide us with June management accounts, outstanding 2016 and 2017 audited financial statements, and all existing contracts, their deal pipeline, and projections for the following 12-month period. To date, all audited financial statements remain outstanding.
Question?
Yes, sir.
Just to check in terms of PIC processes and systems in debt collection or, security packages, debt collection, servicing debts and all that. When you borrow money from a bank, you service your debt immediately, and if you're not paying it, they write letters, they come for you. And I'm just wondering, when you compare the systems that banks use versus what the PIC is doing, it seems that there's a huge gap there. Would you want to comment on that?
Indeed, Commissioner, there is a difference in the banks and how PIC processes are at present. With banks, they are automated systems which send out those notifications of payments due. In the instance of PIC, we depend on the loan amortization schedules which are kept by the finance team, but because when we are monitoring, we keep track of when payments are due, and on the date of payment, we liaise with finance to establish whether or not the bank accounts, they have traced that payment that's coming from the client. And if after finance confirms that there is a payment indeed, or there isn't a payment, we then proceed to discuss or engage with the client as to the reasons. But even prior to that, we always seek to establish a few months before the payment is due whether or not the client will be in a good financial position at the time of the loan installments being due to repay the debt, which is what we did with MST in this instance, 3 months prior to the loan being due. And we got reassurance from the client that they would be in a position to.
Yeah, so are you happy currently with your systems and the way things are, or would you like to get closer to the bank's processes and systems?
Commissioner, it's a significant area that would really improve our processes if we could get an automated system to assist us to track such things and issue breach notices and default letters at the point where the defaults and these breaches occur, rather than having to first initiate a document that must go to legal for them to draft and then have us review and revert to the client on the breaches. So that would explain why in some of these instances you'll find that the default letters are sent a couple of weeks and maybe in some instances more than a month after the actual default event has happened. So it is an area of improvement which I referred to yesterday in my recommendations, that it would assist the team greatly and in managing and minimizing losses of the PIC to have a system that assists us with such dispatching of these notices as early as possible.
Yes, because this is a manual process and things, slip through the fingers, and it seems it's quite a difficult thing to do, from the PIC side.
I agree, Commissioner, but we try to have these gaps covered it is difficult to discharge duties when you have to keep track of all of these requirements or all of these reporting undertakings and compliance areas from a manual point of view. But I understand that there is a system that is being explored, and possibly within the next 12 months we should be able to improve our administration processes around that.
And how many of such loans are you looking after, as a department, in terms of number, roughly?
In terms of the number of clients, it's about 100, but you'll find that in some instances, one client will have more than one type of instrument. So within one client, you could have up to 5 different loans, loan facilities and equity instruments, or various types of instruments. So if on average, I say one client has 2 or 3 facilities, we're looking at about 200 or so loan facility agreements that you would be referencing.
And do you have the same problem with the security packages, the follow-up, and to make sure that the notarial bonds are being processed properly and all that? Besides now the debt servicing, do you have other processes that are better in terms of the security packages, which is a struggle, from this side also?
In terms of the security packages, most of them are usually intact at the point of approval or disbursement. Where a special notarial bond is required is after the client has been given the funds and they have to go and procure or manufacture whatever it is the purpose of the funding was. We have not, in my portfolio, we've not had a problem verifying a security on other investments. This is one where we've committed quite immense efforts and a lot of time in trying to complete that process. But I don't remember any other in the portfolio that have given us this much difficulty.
Yeah, because you see, if you're not following up and people are not seeing notices, isn't it that, people just say, I'm not going to repay this, if they're not seeing effort and, from the PIC to say, you need to pay this loan. Isn't it correct?
It's correct. All clients, by virtue of signing legal agreements, undertake that they will make a payment on certain dates, but where they are not able to, they do refer. Some will notify us ahead of time that we are having liquidity challenges, and hence that would require us to initiate a restructuring process prior to the date of installment falling due. In other instances, we then pick up the defaults after they've happened, and we then try and resolve either by extending the repayment or whichever mechanism we agree with the transaction team to restructure the payments.
All right, thanks.
In terms of quarterly reporting under performance rating, the first report on MST was for the quarter ending September 2017, and MST's risk classification evolved as follows. In September 2017, we classified it as performing, although there was a cautionary concern reported as there were variances against the initial projections. In December 2017, it was placed as a watch list investment due to the security issues that we could not complete, we had not completed at the time. In June 2018, and you'll notice that between December and June, there is no much performance rating because, as I alluded to yesterday, in March we do not submit reporting as it is a financial valuation, year-end valuation process that takes place and supersedes our processes. In June 2018, the investment was placed in distress because of default in repayments and the continued non-compliance in reporting. September and December, they've also remained as distressed because of the continued default position. Under financial performance, from the first quarter after disbursement, the investment reflected strain, loss-making, and deteriorated further until the loan was fully impaired in September 2018. The breaches and non-compliance with registration of special notarial bond and the repayment defaults were reflected in the quarterly reporting submitted to the various committees at each quarter. On the 3rd of October 2018, PMV attended a PMC meeting scheduled to report and discuss distressed investments, one of which was MST. This was a combined meeting for PMV and ESG teams to discuss quarterly PMV and ESG reports, respectively, for the quarter ending June. At that meeting, I was instructed by Mr. Rajda not to discuss the MST transaction. He also asked me to inform my ESG colleagues, Mrs. Bahangwede Banavela, that we should not discuss the MST transaction rather. As a result, the issues on the MST transaction were not discussed at this meeting.
Can I stop you at this point? Do you know why Mr. Raja said you shouldn't bring up the MST issue at the PMC meeting?
He indicated that at this point it wasn't a factual, he wasn't comfortable that the facts were specifically that there had been no buses, and because the client would insist, in fact, that the buses are there somewhere when they would discuss with him, he wasn't comfortable that at this point we appraise the committee and say for a fact that there are no buses. I think he wanted us to explore the matter further and see if there could be any more that could be done before we place it on record that indeed there are no buses.
And this was almost a year later.
This was almost a year later, but the subsequent quarters would have also highlighted that information in the quarter. It's just that at this meeting, it was specifically to have a discussion with the committee and have them note that these events have taken place. But he was uncomfortable because he felt from, I think he's alluded to it earlier, that the client would make different representations, and at some point he felt there was a doubt that we were actually had done enough to find these buses, hence why he said he would rather not have us speak to the matters in that meeting.
Thank you.
But was there any doubt by that stage that there may or may not be buses? I mean, you had been to Cape Town once or twice and never found any 7 new buses.
We hadn't found any buses, indeed, and what we had been given as registration documents related to buses that were old. But because they would want to see key decision makers, and he alluded that he had spoken to them, they would say that everything is in place. So I think from his perspective, there was doubts that we were doing the correct thing or we were following proper processes and applying full efforts to this, because the client is saying something contradictory. And to this date, they still maintain that in the first place, you shouldn't be looking for new buses because that was never the agreement. So at that point, he did say that it would be a bit premature to say that there are no buses because we still have not satisfied ourselves that this is the matter.
Yeah, I'm not sure that I'm satisfied with that. It bothers me. On the one side, client is saying, we never said we are going to manufacture or have 7 buses manufactured. We were not talking about that at all. And on the other hand, you are saying, we don't know whether there were new buses manufactured or not. I mean, how do you reconcile those two?
Commissioner, it's something that's been difficult even to this point, which is why the matter has been taken to PMC to give or make a decision about what is the next action that we can take to satisfy ourselves that indeed there's a distinct contravention in the legal agreements. We, basing on what submissions client had given us for the security package, it was not aligned with what we were following up on in the legals. But they would say that was what we were following up on is not the spirit of the agreement in the first place. That is where the two issues where we diverge with the client is that they're saying you shouldn't have been looking for new buses in the first place, and you are aware of this because at DD stage they referred to in an email that the PIC funding was agreed to have just been a general commercial facility rather than a specific funding facility for the 7 buses. So because of this divergence, we had to get a PMC approval to say how do we proceed given the client maintains their position being they were never meant to comply with new buses, and we are saying we've always known that the funding was for new buses. So the PMC decision that's been taken in this regard is that issue a default letter and just accelerate on that facility and recover what you can. And this has been referred to external legal counsel to deal with going forward.
But I'm sure you realize that you will never find 7 new buses.
Yes, I don't think that the buses, there are no new buses, no, but there are buses that we have been given, and as I alluded to earlier, they are as old as 2011.
Yeah, a broad question, coming from that point, and I do know that you still have to talk to the transaction team, but are there Chinese walls between PMV and transaction teams, broadly?
No, Commissioner. In fact, the level of engagement with the deal team is quite robust and very frequent, to the extent that where we start to experience difficulties in having the client responding to our requests, we always rope in the transactors to assist us, and they do come in. They are meant to be kept abreast of all the developments on their transactions because they have contracted on a particular set of numbers that they have deemed are achievable in the future. There's a target return that is given in appraising the document and getting it approved. There's a target return that we always, or they seek to achieve. And because of our efforts of monitoring, we have to notify them where we start to see the divergence in what the base case was, which was the basis of facts which the transaction team would have had to relate to the committee for approval. Once there's a divergence with that base case, we have to keep them involved because ultimately the accountability within PIC for transactions is with the deal team. So we speak to them on a very frequent basis, and you would see from the statement that I refer to all engagements having come from the different representatives of their teams, our teams, and the other teams.
But they cannot stop you from making some conclusions or whatever. I mean, you do speak to them, but they cannot influence you in any way, broadly.
They cannot influence the activities we seek to undertake to establish what the facts are, but because they have to review with us any documentation that must go to PMC, they review and record. They sign as reviewers and co-compilers. To that extent, it is necessary to have ourselves and the transaction teams on the same page, because then if there is a divergence in views, some of the documents we would require to take to PMC cannot be approved, and that is why even the submission of the document itself is subject to the executive head of the deal team signing that is comfortable with the facts that are contained and that are being submitted to a PMC.
All right, no, fair enough, fair enough.
On client's request for restructuring, on the 5th of September 2018, the client informed us that they were in a better position than the last time we met and would be sending a well-motivated proposal for our consideration. On the 7th of September 2018, the client accordingly sent us a proposal with the following 3 options to consider. First option, to defer payments to April 2019 and commence monthly repayments instead of the biannual repayments. Second option was to further advance 9 million, which the client indicated would be used to settle some of their creditors, then commence PIC monthly repayments from October 2018. And third option, which they said was the first price, is to increase the facility by 24 million to enable MST to repay other lenders and creditors first, then start paying PIC monthly repayments from October 2018. A copy of the proposal is attached as Annexure 13. After considering the options, we discussed together with the transaction team and decided not to support option 2 and 3, and that only option 1 may be further entertained on condition that the client provided the outstanding financials. Upon the client's failure to provide the outstanding financials, we issued a default notice on 12 September 2018, noting the various contraventions of the legal agreements. A copy of the default notice is attached to and marked Annexure 14. In January 2019, we noticed that the client has rebranded itself utilizing a new name without notification of the change of name in contravention of the agreement. Upon inquiry, the client informed us that it undertook the rebranding exercise as a result of the negative media publicity associated with the PIC. The client further failed to provide the long outstanding information regarding the company's strategy and repayment plans and insisted that it will provide this information at the meeting with quote-unquote key decision makers. Copies of the email correspondence is attached as Annexure 15.
My apologies. So on paragraph 24, the client didn't inform you that they had changed their trading name. They just did that. You picked it up.
Yes, we had been corresponding with the CFO, and after one of the emails in January 2019, we picked up that his email address had changed to @extend.co versus @MST Group. And we specifically sent a letter to, well, prior to sending that letter, we asked our ISBA operations team to assist us to check on the database whether the name Extend Mobility has the same registration number on the CIPC as the MST name. And from there, that's where we established that the name change is actually that MST is no longer MST but Extend Mobility. And we then asked just to have it confirmed by the client that they indicate if that was indeed a name change. And in email correspondence, they then confirmed that in fact they had undertaken the full rebranding exercise to disassociate with the impact of the negative publicity associated with PIC.
And from their point of view, they didn't see a problem with rebranding without actually communicating this with PIC?
It would seem it's not something they saw as necessary because they are required. It's a material change because our legal agreements refer to MST, and there is now a company called Extend. So I think just legally it would be necessary for them to notify us as a lender that their counterpart's name is no longer MST but that it is Extend Mobility, so that we can have an addendum to the legals indicating such. Internal decisions.
Paragraph, yeah.
Yes, sir.
Just looking at paragraph 20, the client, asked you guys to give them more money, but given the fact that you were struggling with the financials, the security package, and the buses, there was a dispute about them. I mean, why did the client feel that they could ask for more money, from the PIC?
Commissioner, I can't answer to why they felt it would be a considerable proposal to request us to inject more funding. If we're in the first place, the first funding has not actually been applied correctly. I don't understand why they would think this is a plausible type of option for us to consider, but we did indicate that whatever their proposal is would have to be considered with audited financial statements for us to get a good understanding of where exactly they are in terms of, are they going concern, are they still profitable, and is this a business that is sustainable?
Because I thought when you beg for more money, you must supply the, all the stuff to get the money, isn't it?
That is how it should be, but with this client, not.
Okay.
Internal decisions taken with regards MST. The client's non-compliance with reporting undertakings, in this case audited financial statements, and the lack of cooperation regarding the special notarial bond registration was tabled at the PIC meeting held on 26 February 2019. Due to the fact that a reasonable period had passed during which all team members had made efforts to ensure the fulfillment of the client's obligations to no avail, the PMC made a decision to refer the matter to legal counsel for the purposes of enforcing PIC's rights under the agreement. The PMC further resolved that another default letter be sent, and this letter was duly sent to the client on the 5th of March 2019. A copy of the letter is attached and marked as Annexure 16. The client has responded to refute the contents of the default letter and are requesting to meet with PIC to resolve the matter. The legal department has commenced with the process of briefing external legal counsel on the matter, and as a result, we've been advised to refrain from communicating further with the client until the legal team engages with them. But as Roy has alluded, Mr. Rashid has alluded earlier, this has already been communicated legally by external counsel to the client through another default letter as of yesterday. Commissioner, that concludes my statement on MST.
Question. So, I mean, this company or this work which the company is doing seems to be good work. Healthcare, education, and everything. Commendable work, but I'm just wondering, I mean, what in your opinion or what do you think actually went wrong? I mean, it seems like everything went wrong in this sort of noble effort with some profit potential.
Commissioner, indeed, the nature of the business of a company is that it has a high social impact. They are very visible in what are mostly remote areas where physical infrastructure for some of these government departments cannot be put up. Hence, they provide that mobile solution of catering to specific government department needs and ensuring the visibility of those government departments in different areas of the country. But in this case, what I think this transaction could have gone better had the buses just been manufactured as per specification of the funding. And secondly, if the client could just have cooperated and ensured compliance with reporting undertakings. And in my view, it can't be that the negative publicity related to the PIC girlfriend and girlfriend story has any bearing on whether or not they can conclude their audits, because the two are unrelated. Audits are audits and they are assurance mechanisms. I can't determine what exactly here was the problem, except that lack of cooperation and probably better processes within the client's systems themselves. But they are now using this non-compliance and using the PIC as a scapegoat for not being able to supply this information. And in refuting the contents of our default letter, they do indicate that every instance of non-compliance is at the behest of PIC's negative media issues.
Yeah. The final question is on the recommendations that you had yesterday. I just don't have the page now, but would that include the system you mentioned, the automated system and the other issues? Just if you could come again, then mention them a bit again. Let's see. Do you have the page by any chance there? The recommendations page?
No, I don't, Commissioner, but I am conversant with what I was recommending. In terms of what I recommend as being required, or what could further enhance PMV's processes, is it's a system that's automated, which enables us to gives us more agility in terms of responding to issues such as these. Why I mention it is because, as I alluded to earlier, sometimes the client may deem the period after default, if we haven't provided a notice, they may deem it as a condonement of that breach. And therefore, my recommendation is that if there is an automated system, you're able to dispatch these notices immediately as the event of default occurs. And that should ring a bell to the client to say that the PIC is aware of the non-compliance and does not waive its rights. In fact, we reserve our rights going forward. Whatever remedial action or remedial proposal, the client can come back to us to consider. So that the automation is essentially to assist us to discharge our duties and have these breaches noted as soon as they happen, so clients do not feel that PIC is soft-handed, or that they don't think that it's a condonement of those breaches or defaults by virtue of the length of time it has taken for us to issue those letters.
Okay. All right. Yeah. Thanks. I think I'm done for me.
Can I just ask, on your paragraph 27, the client has responded to refute the contents of the default letter. What are the grounds upon which they rely to refute the contents of your letter?
Essentially, they're saying that all the default events we have referred to in the notice of default, or the letter of default, which is that there have been misrepresentations in terms of how the application of funds was utilized, and in that the purpose of the funding was for the manufacture of new buses, and as well as the failure to report. They're saying that all of these issues cannot be attributed to non-compliance on their part, and that all these material issues have stemmed from the challenges they've had to contend with due to the MST's and PIC's media articles. So what they're saying is, in fact, by us giving them a default letter, we are making serious allegations, serious and false allegations, according to them, to say that they misrepresented themselves in complying with the agreements.
I don't know whether you'll be able to, enlighten us on this issue. There were some allegations mentioned in the Budlander report. I am sure you remember there was investigations by Advocate Budlander in respect, and MST was one of those matters that he was supposed to look at. And he mentions allegations, and I mean they were allegations, that Ms. Pretty Low had some business relationship with MST. Do you know anything about that?
No, Commissioner. In fact, up until the media articles, I did not know of the existence of Ms. Pretty Low. And even pursuant to those allegations, I've still not met Ms. Pretty Low, and I have not come across her name or involvement in any of the monitoring that we've been doing. So I do not have any information on her involvement at all.
Fair enough, okay. And the last question from my side is, what do you think, are there any lessons to be learned from this transaction? Lessons in particular relating to whether the PIC should advance loans and not make sure that the money is going to be utilized for the purposes that it was, I don't want to use the term purportedly sought.
Commissioner, I would think on a transaction such as this, which is contract financing, maybe what could be considered going forward is instead of just dispatching or dispersing the funds directly to the client, maybe we can request that client provides supporting documentation for procurement of whatever it is the purpose of the funds is. And then against that, we would make the payment just to satisfy ourselves that the funding has indeed gone to the supply of that, the supplies that the customer or the client needs, to the extent that it doesn't interfere operationally with the client's day-to-day activities. But I think because we were financing specific assets, maybe what we can consider going forward is paying directly or on the back of an invoice, which we can then trace such payment with once the payment has been made.
Just a follow-up question from the judge here. Does PMV monitor CSI funds, from the PIC? Because there was that 5 million which was given out.
Commissioner, PMV does not monitor any of the specific PIC corporate matters. So if there are any CSI projects which are linked to an investment that has been funded, that part of the CIC is not monitored by PMC. It's considered the PIC corporate's matters, and we deal with only the investment-related aspects.
Yes, Ms.
Matsikanda.
Thank you so much for your time, and thank you so much for the evidence that you have placed before us. We really appreciate that. But again, whether this is it for you, you might be called again to come back and enlighten us on some aspect. We don't know, but for now, thank you very much.
Thank you, Commissioner.
Okay.
Commissioner, I just wanted to provide some clarification on the pretty low issue. She was on the 5 million CSI one and not the 21 million MST one.
That's fine. That's fine. We shouldn't debate it.
Commissioner, at this point in time, I'm told by Mr. Mahapi, my colleague, that he's ready with the next witness.
I think there was a request that Mr. Raja comes back for a few minutes. We can take a 5-minute break for that, just to arrange the chairs again.
Your wish is my command. You can sit down. Yeah. You can sit here.
record from the Butlander report. Ms. Lowe is not a shareholder or director or employee of MST, but she did have a commercial and financial relationship from which she derived financial benefit. They run a company called Maison Holdings, and I'm not reading it exactly, which is a vehicle for a number of current or intended businesses. And MST, Maison Holdings was introduced to MST by Mr. Wiseman Kumalo when he was seeking a partner for submitting a tender to the KwaZulu-Natal Education Department. And in April 2016 was the first meeting with MST in that regard. They entered into, in July 2016, so after the June meeting about improve your BE credentials, they entered into a formal joint venture agreement with MST, which was termed a consultancy and joint venture agreement. It provided inter alia for the following. MST is the owner of mobile units which seek to supply various government departments in South Africa. MST was approached by Maison with a proposal of sourcing clients on behalf of MST in order to supply mobile units to them. They had identified a number of potential clients to supply the mobile units and has the experience and skills to facilitate a sale and supply of mobile units to various clients. MST engaged the services of Maison to procure suitable clients, and Maison would also be responsible for the business development and account management of the projects brought on by them. So they were appointed as consultant and facilitator, with the primary objective of Maison will be to facilitate, negotiate, and procure the conclusion of an agreement in terms of which the client will either purchase or rent the mobile units from MST. For this, they'll be paid a facilitation fee. And this is an important question. In April 2017, MST paid Maison Holdings 438,000 Rand plus VAT for work done to date, and this is the reason stated in an email from MST to the PIC. So the question being asked is that the payment was made to look at improving BE status and motivate and stimulate our partnership to create further sales. And what I'm asking you is this set up with MST Maison Holdings introduction by a minister through the CEO related to the recommendation that this requires an improvement in your BE status and a female operational contract, because then there's something else going on here that does not look very good. Ms. Lowe undertook to provide a copy of the invoice, which was never shown to the Butlander Commission, and in the MST ledger it is reflected as consulting fees, but it is a joint venture. Now you then follow that with a CSI of 5 million, which was related to Ms. Pretty Lowe as far as I understood the initial discussions, and a 21 million Rand loan to MST. Can you let us know exactly what you understand was going on here? Because this does not sit very comfortably.
Through you, Commissioner. Thank you. I'm aware of the agreement. I think it was myself who had submitted that agreement to the Butlander inquiry. If I can start with
Sorry, which agreement are you talking about?
There's an agreement between Maison and MST, which Ms. Marcus is reading a lot of the information from.
And you say you made it available to the Butlander
Yes, I had made it available. If I can start, as I understand it, and I don't have the dates of it, but I think the date of the agreement might have been around when the 21 million or predated. I'm not quite sure. But what I can say is that we were aware of when the only time that we became aware of that agreement is when the publicity started. Then we started asking for this kind of information. And at the time, what I was made aware of by the CEO of MST was that Maison Holdings had been assisting MST in introducing them to various clients. Now, off the top of my head, I remember them saying Department of Economic Development in KwaZulu-Natal, Road Accident Fund is the two names that come to mind. So, but there was no conclusion of any transaction. They had introduced them, but it never resulted in any benefit. So, as I mentioned earlier in my testimony...
Sorry, just to be clear on that, because the agreement was in July 2016 between MST and Maison, but just to be clear, what you're saying is that although they introduced them to a number of entities, Road Accident Fund and others, there was no business outcome concluded from that. It was an introduction and that was it.
Yes, there was no... there was
no realization of a deal.
That's it, that's true. There was no realization of a deal. Now, if we take... so when when I had first met with Ms. Pretty Low, it would have been shortly after the conclusion of the, as you'll know, the first time there was an approval of 30 million rand, but that was not accepted by the client. Then the second time there was an approval on the 8th of June. That was the final approval, and I think disbursements happened on the 6th of July. So I think probably about a month or two thereafter is when I had met Ms. Pretty Low at the PIC office. And at that meeting, she had been discussing the issue about doing some joint venture with MST. There was a bit of confusion in the meeting because I thought, but why is she coming to the meeting now when we had already concluded the transaction? So that we were talking at cross purposes. She was referring to a CSI discussion, which I was never part of, but then eventually I figured that she was talking about a CSI initiative. And I had mentioned in that meeting that the CSI initiative does not fall within my domain. That falls within the domain of the, in the finance, in the CFO office. So that was the discussion there. Subsequently, we were furnished with a proposal of funding between 23 million rand and 37 million rand. On CS, because my team had already worked on this project, my team took that proposal and went to EXCO. Because it's a corporate decision, it wouldn't go to PMC, and the EXCO was not comfortable with that. They felt that they liked the project, but felt that the amount was too much. And at that meeting, the general manager of finance was instructed to go and look at what budget was available, so that that could be committed. And then what I had undertook is that given whatever, if there was a budget, I could look into other investee companies in terms of their spend or their BBBE to augment that contribution. So I think it was around about in January or February the following year that at EXCO it was decided let's commit an amount of 5 million rand, and that was in anticipation of the 31 March year end coming and PIC also having to contribute to CSI. So that was how then that 5 million was dealt with directly with MST. So their proposal of the 23 to 37 million rand involving a joint venture with Mason, that was dispensed with. We didn't agree to that. Now subsequently, when more of these media articles were coming out and we were getting queries, one of the questions asked was, did Mason receive any fee? And that is when I had sent, I don't know whether I had sent an email or I had spoken to Mr. Fernando about the amount, and then he told me, then they sent me an email saying it was 438,000 rand. Now I think that if we say the 438,000, I don't think it would be on a consulting fee, but if you add VAT to it, you'll see that amount is going to come to exactly 500,000. Right? So one could also say 500,000 rand is 10% of 5 million rand. Right? So that's the only thing I can't say with certainty, but the amount rounds to 500,000, it amounts to 10%. That's the only thing I can deduce from it.
I could just try to go back to the timelines a little bit, because it's a question that Ms. Lowe's, according to the Butlander report, and I'm going with that, Ms. Lowe's first contact with Dr. Machila and the PIC was on the 4th of April 2016. At that stage, Ms. Lowe had no connection with MST. Her first contact with MST was on about 22nd of April 2016. And from there onwards, then we get into all the PIC's decision-making processes, and MST sends Ms. Lowe a proposal for the PIC on the bus issues, and then there is a request for the CSI funding. And on the 9th of June, Dr. Machila sends a message to you with a comment for the 5 million, please assist. And therefore, the connection relates back to that, in my mind, the connection relates back to that meeting at the airport. So if this is the outcome of it, then what other influence in relation to business with the minister or business with government relates to Maison? And that is the purpose of the MST Maison joint venture. So my concern here is there seems to be a process by which there's a meeting, there's a request, there's a connection made to MST, there's a CSI, you pay the CSI 5 million, and there's a fee paid for services rendered, which the PIC is notified on, that this is the fee paid. It does call into question the decision making. And I accept you may not have been part of all of that, but it does raise questions about process and the way the decisions are taken for me.
Through you, Commissioner, all I can say is that through various stages of the transactions we had done, as far as we were concerned, we had followed process, we are unaware of things until the media coverage was coming out. Then we had to go back and try and look at things. But as we had done the transactions, it was just in the normal, ordinary course of business, and we never, let's put it this way, I mean, it was just like any other transaction.
Accepting. You see, my concern comes back to the minutes of that meeting. If you create an expectation or an assumption that in order to qualify for a PIC in a legitimate manner, a properly invest, this is a good business, we are coming to the PIC for funding, and the concern expressed by the committee is, the committee emphasized that MST should improve its BE level through incorporating a female BE group in the shareholding and a female at operational level. Are you not creating the circumstances in which this kind of activity is inevitable?
I take the point, Ms. Marcus.
But as far as you're concerned, you don't know of any amount. This 480,000 that we are talking about did not come from the PIC, as far as you're concerned.
As far as I'm concerned, it didn't come from PIC, and it is MSTU actually confirmed that they had paid the 438,000 rand, excluding that, to Mason. So they have confirmed that.
But why would they have confirmed to the PIC if it was a joint venture between them, if it was not relevant to the PIC in relation either to the minute or to something else? Why would they have put it in a letter to you that they've paid a consultant fee?
I think there was a question raised, I'm not sure whether it was from the media, but there was a question that was raised as to whether any fees were paid. So I merely requested it from MST, did you pay any fees? And they confirmed that they did.
And do we know if this was the only fee? Or is this the only fee that was recorded at the time that you had? Because again, if it was the only fee, then there's another question. Because then the question of a joint venture and ongoing activity in relation to that comes in.
To the best of my knowledge, I only know of that fee that was paid. That is what MST had communicated to me.
And what would they have paid it for? Was it in respect of the 21 million or something else?
As I say, I'm not 100% sure, but I was trying to deduce that if we take 438,000 rand excluding that, and if you add on that, it would come to 500,000. So the only thing that I could think of, I mean, if I'm looking at it, is that 500,000 rand is 10% of 5 million rand, which is a CSI. That's the only connection that I could make. However, I must add that the CEO of MST had told me that the amount that was paid was not in relation to anything specific, but rather because of the overall effort that Maison Holdings had put in introducing them to various things. That is what he told me.
But if I go back to paragraph 36 of the Budlander report, and to read it in full, on the 1st of April 2017, MST paid Maison Holdings the 438,000 plus VAT, quote, for work done to date. That's the reason stated in an email from MS to the PIC, and it continues. The email also stated that, it goes back to the question of the minute. The payment, quoting, the payment was made to look at improving BEE status and motivate and stimulate our partnership to create further sales. So the interpretation has to be that this was something that came out of that, the PIC approach, from that response from MST to the PIC, and that's the reason why you got the letter. And that's April 2017.
Just to ask a question as she is busy there, if you can sort of remind us, what was the CSI projects for? Just if you can sort of remind us about that.
Yeah, I think the CSI was on the education buses.
What was it, sorry?
Maths and science. On the maths and science
buses?
Buses, yeah.
Was it a bus? Was it buses? Okay. Then the next one, in terms of timelines, you are saying that you got the transaction from Ms. More, and then we got the other story about the airport meeting. Which is which? Which, you know, who actually gave you to look at the transaction? Which came first and which is which? I'm confused, you know.
The first transaction relates to the 21 million rand loan. Mm-hmm. That was a transaction that Ms. Mora had met somebody who she didn't mention to me at the time. And thereafter, on the 2nd of July, she had sent through, the client had sent through the documents through to her, and she had forwarded it through to me. So that related to the 21 million rand loan.
Yes.
Well, okay, the initial application was 45 million, culminating eventually in a 21 million rand loan. So that, so that related to that loan. Sure, maybe about 2 months or so after the conclusion of that transaction, when I mean conclusion, I mean in terms of disbursement. Thereafter, we had between 23 million rand and 37 million rand request for a joint venture between Maison Holdings and MST coming to us, and that request is from a CSI perspective, not from client funds. But ultimately, We didn't fund that. We had given CSI funds directly to MST to the amount of 5 million rand.
Just in terms of the date, so the Ms. Moore's sort of note came before the airport meeting or after that? I just want to sort of clarity on that one. Do you know? Can you remember? Oh.
I think Ms. Marcus gave a date somewhere in April 2016, I think, as
So
the
it
airport
came
meeting.
before, yeah?
So this would have been, the 21 million would have been before that.
Yeah, okay. All right. Just the one thing to follow up on then is that, you know, given that there are some issues about how transactions come to the PIC in general, it looks like, you know. Do you think amongst our recommendations we should include the fact that, you know, people must note strictly and in writing how they got transactions and why and those kind of issues?
Through your Commissioner, I would agree to that, that where transactions come through, perhaps it must always be disclosed the source of the transaction. How did it come to the PIC? I think that would be a recommendation.
It seems that's it, Mr. Raja. Thank you once again.
Thank you.
I'm not going to say you must stay here, not go, in case they want you back again. But thank you so much.
Thank you, Chair. In 2 days, I've been here 4 times.
No, I think for today, I must say you're excused.
Thank you, Commissioner. I think we can take the lunch adjournment if it suits you.
I didn't realize that it was 1 o'clock already. I think we might have been enjoying the session. Yes, we'll adjourn until 2 o'clock. Ms. Mdluli, do you have any objection to taking the oath?
No, Mr. Commissioner.
No objection.
No
Do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth?
Yes, Mr.
Raise your
Commissioner.
right hand and say, so help me God.
So help me God.
Thank you. You may be seated.
Thank you.
Ms. Mdluli, you've prepared a statement which, in relation to the evidence you're going to give before the Commission, is that correct?
Press once, Ms. Mdluli.
Through you, Mr. Commissioner, yes, it is correct.
Were you compelled to prepare the statement?
No, I wasn't compelled.
And were you compelled by the evidence leader team to put things in your statement which you did not agree with?
No, I wasn't, Mr. Commissioner.
So the evidence you're going to give to the Commission relates to the VBS transaction, is that correct?
That is correct, but it's with relation to the 350 million rand facility as well as the rights issues.
Okay.
Thank you.
Let's proceed with your statement, starting from paragraph 1.
Mr. Mohabi, can you arrange for her mic to be closer to her, please?
Okay, I, Brenda Buyisiwe Mdluli, an adult female, confirm that the contents contained in the statement are within my personal knowledge and are to the best of my knowledge true and accurate. By way of my education and work experience, I have obtained the following qualifications: a Bachelor of Commerce degree majoring in corporate and investment finance, business information systems and information systems technology from the former University of KwaZulu-Natal. I have a higher diploma in tax law from the University of Johannesburg, a certificate in advanced company law from the University of Witwatersrand, and I am a FSCA certified FACE representative. My working career started in 1999 as an administration assistant working for a company called eThekwini Business Development Center, currently known as SEDA eThekwini, that assists small businesses with business advisory services. I moved through the ranks to my last position as a senior business development officer. In 2005, I was appointed as a portfolio assistant at Umsobomvu Youth Fund, which is currently known as the National Youth Development Agency. And I started as a portfolio assistant, and then I was promoted to an investment officer in 2006 and 2010. And then in March 2010, I was appointed as a project manager at the PIC. And then from being a project manager, I was promoted to an investment associate and have been an associate principal since November 2016.
You started off in the Isibaya Fund.
Isibaya Fund, correct, Mr. Commissioner. I have been an employee of the PIC since the 15th of March 2010 with uninterrupted service, holding various positions within the Isibaya Fund Impact Investing Division. I'm currently an associate principal within the Impact Investing Division. I have been requested by the Judicial Commission of Inquiry into the PIC to make a statement detailing my role, responsibilities, and involvement in the PIC investment in the VBS mutual bank transaction.
Just before you get into that, associate principal, impact investing.
Correct, Mr.
What's the nature of your work there?
The nature of our work involves screening of transactions, compiling or reviewing appraisal reports, presenting them to a committee and recommending them for approval to a committee.
And those are things that you did in relation to VBS, is that correct?
That is correct.
Okay.
Can you, maybe for clarity, give a bit of a pecking order from, say, the analyst up until to the highest point? Yeah.
Okay, it's the analyst, it's the investment associate, it's associate principal, then it's the fund principal.
Fund principal.
Yes.
So you are in the sort of second most powerful position before the executive head. Is that correct? No?
I wouldn't say most powerful, I would say...
Second, that's it, second most powerful. Okay.
I'm not sure about powerful, say.
Oh, okay.
Yeah, that's
All
the
right.
one
Okay.
that I'm not sure
Let's
about.
leave it there. Yeah. That's fine, that's fine.
Okay. If I move on to the outline of my statement covers the following. Number one, my involvement in the 350 million rand revolving credit facility advanced by the PIC to VPS. That is termed the facility in my statement. The review process of the facility. Number three, whether the approval conditions of the facility by the priority sectors, small and medium enterprises fund investment panel, included the following provisions that are in the facility agreement. There is clause 3.5, which reads as follows. The facility shall be ring-fenced for its purpose as defined in the agreement, as shall be subordinated as against other creditors or borrower creditors. And clause 3.6, which reads as follows. The facility outstanding amount or any portion thereof may be converted into equity at the discretion of the lender at any time before the final repayment date.
While we're there, Ms. Mdluli, can you just explain the concept of ring fencing?
Basically, ring fencing is protecting an asset and you segregate it to be separate from the normal operations of the existing operations of the bank, so that you will always have control of the money that is going for that facility. I don't know if that is clear.
Okay, we can proceed. We will explore that further in your statement.
For my purposes, because I don't know much about investing, what is a revolving credit facility?
A revolving credit facility means you have access to the facility, and once you've used it, you will have access to it until it's top up, but it cannot be more than 350 million. Every time you use it, you have to repay to retain it to the 350 million that it was approved.
So the way it works is there's a drawdown on this total amount that you have at your disposal, and you have to repay it, and at that, it always has to stay at the maximum of 350 million.
Correct.
Is that correct?
Correct.
Yep.
Okay, can I continue? Okay. Okay, my involvement in the transaction relating to the facility. I got involved in the transaction relating to the facility on or about March 2014. The facility was approved as a ring-fence revolving credit facility to be utilized to fund VPS's contract financing book, which form part of VPS strategy to diversify its product offering and revenue-generating activities by introducing new products. The application for the facility was first introduced to me or to myself by Mr. Paul Magula, who was then the associate principal of unlisted debt within Isibaya Fund. And he was also an alternate director to Mr. Nesane on the board of VPS, and was also my senior in this instance. Because at the time of this transaction, I was still occupying the position of an investment associate, not associate principal.
So they sit on the VBS board, that is Mr. Magula and Mr. Nesani, by virtue of the PIC having shares in the bank, is that correct?
That is correct, Mr. Commissioner. As a standard at the PIC, the first internal step in a transaction is to compile a scoping report. The scoping report in respect of the facility was compiled by Mr. Paul Magula. Given that Mr. Magula, although my senior, was at the time new in the division, he required assistance in understanding the processes and the structure of the report. My colleague, Ms. Kinti Yende, and I assisted him by reviewing the scoping reports in respect of the facility. On the 13th of May 2014, the investment team, which was comprising of Mr. Paul Magula, myself, Brenda Mdluli, and Ms. Kinziende attended the first Portfolio Management Committee unlisted meeting and presented the scoping reports in respect of the facility. The meeting approved the scoping reports in respect of the facility and authorized the team to proceed with an internal due diligence investigation, meaning that the due diligence process will be conducted by internal PIC personnel. During May 2014, Mr. Makula compiled the appraisal reports also, and he was the person who was responsible for the collection and collation of information and all the interactions with VPS.
Just to stop you there, Ms. Mruli, when he was acting in this capacity and preparing this appraisal report, was he already sitting on the VBS board?
He was an alternate, if I remember correctly, he was an alternate director to Mr. Nesane at the time.
Okay, all right.
Okay, during May 2014, Mr. Magula compiled the appraisal report. Okay, upon conclusion, of the appraisal report, Mr. Makula requested us to review his appraisal report. Notwithstanding the fact that I only reviewed the appraisal report, Mr. Makula designated me as a compiler of the report. And the appraisal report was presented at PMC on the 29th of May 2014. Thereafter, the transaction was recommended for approval by the PSSME FIP on the 24th of June 2014. And on the 24th of June 2014, the PSSME FIP approved the facility based on the conditions, and there were conditions set for the facility, which I would like to make a correction, Commissioner. I will refer to point 18 of my statement, not point 14.
Okay, that's paragraph 18.
Yes.
Thank you.
And then on the 1st of October 2014, Mr. Makula was then appointed as the acting chief risk officer and moved from the Isibaya Fund to the risk division. As he was the investment team lead at the time, I was expecting that Mr. Makula was going to continue with his role in finalizing this transaction after the PSSME FIP approval, but instead he went silent and did not respond to email requests for comments on the legal agreements that were sent through by the then legal representative, which was Mr. Ernest Nesane.
Let's proceed, paragraph 14.
Okay, paragraph 14, it's in relation to the review process of the facility. Clause 18.1 of the revolving credit facility agreement that was signed between the PIC and VBS reads as follows. The facility is subject to review on an annual basis. The lender is to be provided with a copy of the borrower's audited financial statements, which are to be provided within 6 months after the borrower's financial year end. The PIC Portfolio Management and Valuations Division undertakes the responsibility of facility reviews. I was involved in facilitating the flow of information between the PMV division, in this instance, my former colleague, which was Yolanda Makwenji, who's no longer working for the PIC, and Mr. Kaya Zonke, who's currently at the PIC, were the personnel who were leading the facility review process in VBS. For ease of reference, I have attached email communication to confirm the information flow facilitation marked as Annexure A.
So your Annexure A is constituted of a series of emails and documents which were part of that process, is that correct?
Correct, Mr. Commissioner.
Okay, let's proceed, paragraph 16.
Okay, I cannot confirm how the PMV undertakes the review process. The PMV team is best placed to respond to the issue of the review process and compliance therewith, as they are the ones who were responsible for the review process of the facility. I can confirm that I did not see the review report, and I was not expecting to see the report, as it was supposed to be an independent review, which is independent to the investment team, and it was supposed to be presented at PMC.
Just taking a step back, Ms. Mdluli, the relationship between the PIC and VBS, since you're the first witness testifying on VBS, as I understand it, VBS was a legacy investment. Can you explain that to the Commission?
On the legacy issue of VBS?
Yes, so it was an inherited investment.
Yes, it was.
As I understand it.
Okay, I'm trying to find the document that talks to that.
Or to put it simply, the PIC had a pre-existing relationship with VBS where it had inherited basically.
Yes, it had.
This investment.
The government pension fund of vendor was a shareholder in the vendor building society. And then the PIC became a shareholder of VBS Mutual Bank with the enactment of the government employees pension law, which was enacted in 1996 on the 1st of May 1990. And Section 14 of the GEPF law provided for the discontinuance of the government pension fund of vendor as well as the government superannuation fund of vendor, and for these funds to be amalgamated into the government employees pension fund. So this is how PIC inherited the VBS Mutual Bank transaction. So it was an existing client of the PIC by that enactment.
What are you reading from?
It's
information that you've just read into the record. You're reading it from what?
It's from my notes that I prepared, Mr. Commissioner.
Your own notes that you prepared?
Yes, Mr. Commissioner.
Is there perhaps a document which we can source which would have that information and which we can then provide to the Commission?
Yes, I think we can provide it to the Commission.
I confirm, Mr. Commissioner, that we will provide that a document that gives the background of the relationship between the PIC and the bank.
I'll appreciate that. I know I also read it somewhere, but I can't remember where. All right.
We will provide it to the Commission.
Okay. And then the approval conditions of this facility. The facility was approved on a ring-fence basis, as mentioned, to ensure that it was operated separately from other product offerings by VBS. The conditions of the approval of the facility by PMC and PS SME FIP did not include the following revised or amended underlying conditions which were included in the facility agreement post the approval.
So just to be clear, the parts in your statement which are to follow, which have been underlined, are things which were inserted post-approval?
Correct, Mr. Commissioner.
Okay. We can proceed. And then when you just mention the parts which are underlined, you can just mention that these are things.
The clause 3.5, which reads as follows: the facility shall be ring-fenced for its purpose as defined in the agreement. As the part that is underlined is the part that was not part of the approval. As such, shall be subordinated as against other borrower creditors. And the second clause was clause 3.6, which reads as follows: the whole clause was not part of the approval. The facility outstanding amount or any portion thereof may be converted into equity at the discretion of the lender at any time before the final repayment date. And the legal department personnel at the time who settled the draft facility agreement would be best placed to explain the rationale for the inclusion of the above clauses.
Can we just spend a moment on these clauses, Ms. Mdluli? So the first part of clause 3.5 talks about ring fencing the facility.
Correct.
Then the second inserted part talks about as such shall be subordinated as against other borrower creditors. That's a contradiction in terms, isn't it?
According to my understanding, I don't think you can ring fence a facility and at the same time subordinate it, because it's supposed to operate separate from any other creditors or any other operations of the bank.
So with what has happened to VBS, the idea with ring fencing was to protect the loan, the facility given by the PIC against VBS's other creditors.
That's correct.
The fact that now it's been subordinated has deprived the PIC of that protection, hasn't it?
That is correct, Mr. Commissioner.
And also in relation to clause 3.6, to convert the facility into shares is also a contradiction in terms with the ring fencing, isn't it?
And that was not the intent of the facility in the beginning. Even at approval, no one talked about the facility being converted into equity.
Thank you, Ms. Mdluli. Let's proceed. Paragraph.
Just to double check, so 6A, 6.3.A is that, so the problem is there is that you have done the is the subordination part. The second one, it looks like it reads the same kind of wording, yeah? It's correct, but it was not supposed to be convertible.
Yes.
And this point wasn't in the shareholders, in the agreements. Is that?
This point was in the facility agreement, but it was not part of the approval conditions that were approved by the fund investment panel.
Yes. Which part is this now? The 6.3.B, 6.3B.
That is okay. It's 18. And it's B of my statement, but the clause is clause 3.6 in the facility agreement.
Okay, all right, okay, all right.
Okay. On the 13th of April in 2015, an email addressed to myself and Mr. Makula was received from Mr. Nesane requesting us to comment on the facility agreement, which was attached to the email before it could be issued for signatures. I then printed that version of the document to read through and wrote down my comments on the printed hard copy version. This version of the facility agreement did not contain the two clauses mentioned above, which is clause 3.5 and 3.6. For ease of reference, a copy of the emails have been provided also to clarify that statement.
Sorry, just for clarity, Ms. Mdluli, when we refer to clause 3.5 and 3.6, we're referring to those clauses in the facility agreement.
Correct, Mr. Commissioner.
Okay, thank you.
And then on the 23rd of April 2015, an email was received from Mr. Nesane, again addressed to myself and Mr. Makula, with two attachments now, which were the facility agreement and the session of underlying contracts agreement. He indicated that these documents were execution versions and requested us to comment or recommend changes before signatures. On receipt of this email, I realized that I had not sent my comments earlier as he had requested, and I had already written in my hard copy printed agreement the comments that I wanted or the changes that I was recommending to the agreement. And then on the afternoon of the same day, which is the 23rd of April 2015, I sent a response email to Mr. Nesane by working through my handwritten comments on the hard copy printed document that I had printed. I was under the impression that the document that I had printed was the same document that I received on the 13th of April 2015, as Mr. Nesane did not mention that there were any material additions or changes to the first document that he had sent or that we received. The document that I emailed back to Mr. Nesane with my comments had clauses 3.5 and 3.6. I think I might have missed the insertion as I was working from the printed hard copy document without these clauses. A copy of the email is also provided for ease of reference.
Just to interrupt you there, Ms. Mdluli, so if you can just take the Commission through the process of putting together agreements in the PIC, there would have been an investment approval process.
Correct?
You would have resolutions for approving the investment.
That's correct.
And those have to be incorporated in an agreement, and it's the legal division's responsibility to incorporate those into the agreement.
That's correct, Mr. Commissioner.
Okay, thank you.
Happy. Reference is made to a copy of an email provided for ease of reference. Where is it? Is it one of the annexures? There's another one before this, another copy of an email. And there's no annexure reference for it.
The emails have been provided to the Commission separately to the annexures, Mr. Commissioner. We thought it best to provide them as they are electronically, but they have been provided to the Commission and will be made available.
I was not aware and cannot confirm when the clauses 3.5 and 3.6 were added to the agreement until at a very later stage during the announcement of the decision to place VBS under curatorship in March 2018. And an additional condition which was part of the resolution from the PSSME FIP was that the facility drawn down will be such that 200 million rand will be drawn initially and the 150 million rand to be made available in line with the performance. I can confirm that this condition was not included in the facility agreement. I cannot confirm that I was not aware of this, but I assume that as the disbursement was done in tranches, this condition was fulfilled.
Could I ask you, given the amount of documentation flow in different versions, does the PIC have a methodology by which all of you follow to know which version you're on and who has seen and signed off and approved which version, so that you know you're on version 7 and XYZ have all seen it and ticked yes, this is, so we're all working off the same page and I'm not on version 1 and you're on version 3 and somebody else is on version 7? Do you have a methodology that is followed in all the departments, including your own, that allows the tracking of which version of what document and who has seen it as a matter of course?
Through you, Mr. Commissioner, I don't think we have a system or a process that talks to that. But the person who is in control is the one who will either be sending you information or sending you the documents. They will have the original document and they will have all the review documents as well.
Can we just look at that as going forward? Because if this is applicable, not applicable here, elsewhere in the organization, otherwise you don't know where you are in terms of what is being finally agreed. People will have a different understanding of what has been finally agreed if you're not working off the same document or same version of document.
But just in relation to the Commission's question on this aspect, it would have been Mr. Nesane's responsibility to ensure that the finally adopted document has all of the relevant approvals and that it's the correct document that would be executed upon.
That is correct, Mr. Commissioner. The legal representative is the one who's the ultimate responsible to making sure that whatever is in the legal agreement is as per the resolution or as per the approval by the fund investment panel or the committee that approved the transaction. And then paragraph 25 is in relation to the process that was followed, which resulted in the PIC participating in the second and the third rights issues simultaneously. On the 8th of May 2017, I received an email from Mr. Philip Truter, who was the CFO of VBS, addressed to my colleague, Ms. Lufuno Nechuketa, and I. The email contained a notice to the shareholders of VBS dated the 28th of April 2017, stating that the board of directors of VBS had resolved to extend the deadline of the second rights issue up to the 31st of May 2017. The initial notice of the second rights issue was not sent to me, and to the best of my knowledge, was also not sent to anyone at the PIC. This notice, the initial notice of the second rights issue was allegedly sent to the shareholders around August 2016. As the initial notice was not sent to the PIC did not participate in the rights issues of August 2016, and this had the effect of diluting PIC's shareholding in VBS from 25.26% to 11.96%. I contacted Mr. Truter immediately to understand the contents of the second rights issue notice that was contained in the email of the 8th of May 2017, as there were no records of receipts of the initial notice of the rights issue by the PIC as a shareholder. I also sent him emails to that effect. I stated in the emails that the PIC should be given a fair chance to also undergo the internal processes of making a decision of whether they are participating in the rights issue or not. The PIC team, which was myself, Brenda Mzuli, Lufuno Nechikweta, Kaya Zonke, and Yongama Melapi of PMV, requested a meeting with the VBS CEO, which was Mr. Andile Ramabunga, and the chairman of the board of VBS, which was Mr. Chifiwa Matodzi, to discuss the participation by PIC in the second, extended, and the third rights issue. On the 26th of May 2017, VBS had a board meeting at the Indaba Hotel in Fourways. During the break of that board meeting, the PIC team held a meeting with the VBS CEO, chairman of the board, and the CFO. The PIC team advised the VBS colleagues of the PIC standpoint with regards to the unfairness of the process that would lead or led to the PIC shareholding dilution.
Just before we move on, Ms. Mdluli, was the PIC, was this team constituted of yourself, Lufuno, Kaya, Yongama, was it invited to the VBS board meeting?
Through you, Mr. Commissioner, we were not invited. We have been trying to get meetings with them, and they seemed to be busy at the time until they told us that they're going to have a board meeting, and we insisted that we must meet with them so that we will get to make a decision on what needs to be done about the fact that PIC was not given fair notice to participate in the rights issue.
At this time, were the two PIC representatives, Mr. Magula and Mr. Nesani, on the board?
Yes, through you, Mr. Commissioner, yes, they were part of the board.
So although they were board members, and they would have then been aware that the PIC had not been informed as board members, because they should have been aware of what the rights issues were and what was happening. Is that correct?
They would have been involved, through you, Mr. Commissioner, they would have been, or they would have known about that instance.
Okay, let's proceed, paragraph 28.
Okay, subsequent to numerous discussions and email correspondence, it was then agreed that VBS will give the PIC an extension to exercise both rights issues in respect of the initial notice and the extended notice at the same time. This resulted in the PIC approving via round robin to participate in the second, which was the initial and the third extended rights issue at 90 million rand, and the original shareholding of the PIC at VBS was restored to 25.26%. I have attached correspondence between the PIC, represented by myself, and Mr. Truta on this matter for ease of reference, marked as Annex B.
Once again, when referring to Annex B, that's a series of communication, emails, and documents exchanged between yourself and the VBS CFO, Mr. Truta. Is that correct?
Through you, Mr. Commissioner, yes, that is correct.
Thank you. Let's proceed. Paragraph 31.
Okay. Vele Investments Pty Ltd, shareholding in VBS. In the course of finalizing the report to be approved by PIC on the participation in the rights issue discussed in paragraphs 25 to 30 above, it came to the attention of the team that there was a new shareholder, namely Vele Investment, which was initially not known, that had suddenly held 53.20% shares in VBS. Ms. Lufuno, Nechikweta, Ms. Kintiende, and I inquired from VBS about this shareholder, and we inquired or asked questions through Mr. Philip Truta, who was the then CFO.
And this shareholding was, or by Vele, was prior to the rights issues?
That was prior to us exercising our rights issue.
Prior to you, but the rights issues that they may have
yes,
done it from the previous rights
correct.
issue that you were not included in.
That is correct. Okay. Mr. Truta informed us that this shareholder was part of the other shareholders, which is the other in, because there's a shareholding which is, I think it's various organizations and individuals which held about 49% of VBS. So when we inquired, he told us that this shareholder was part of those other, and the various that participated in the second rights issue, when the major shareholders, which were the PIC and Yambeu Investment, did not participate. My understanding of the rights issue is that it is an issue of shares offered at a special or discounted price by a company to existing shareholders in proportion to their current shareholding of shares. Hence the reason that the team had to understand the strange appearance of the new shareholder.
Now, just going back to this strange new shareholder, Vele, it's public record that it was one of the biggest recipients of the so-called ill-gotten gains from VBS. Is that correct? Vele Investments was one of the biggest recipients of ill-gotten gains from VBS in the...
I think according to the Great Bank Heist report by Advocate Terim Tau, that's where that information is coming out.
And do we have more information on exactly who Vele Investments is? And the...
We can also make that information available to the Commission, Mr. Commissioner.
Do you have it readily to hand or not?
Sorry?
No?
Sorry, pardon me.
Is, or who exactly Vele Investments are, who the people involved in, do you have that information easily to hand, or is it something that you would need time to provide to the Commission?
It is available. It is information that we have available, Mr. Commissioner, through you, and we can make it available to the Commission.
I'm asking, though, if it's to hand, because you could read it into the record now. If it's not to hand and you need to give it to us later, that's fine.
We'll do so.
I'm sure we'd have it in the report. But I'll look for it and get it.
Mr. Commissioner, that concludes Ms. Mdluli's evidence. Our next witness is ready to testify.
Just a few questions.
Given the events that you indicate occurred relating to the rights issues and your concerns around what was happening, was there discussion between yourselves as the PIC and the two board members who were there at the behest of the PIC about what was actually going on, what was happening at VBS?
Through you, Mr. Commissioner, the VBS representatives, they would usually tell us that they are board members. They are not PIC representatives in terms of like a shareholder representative when it comes to board matters. So those roles should be separated.
I accept that because they obviously have a fiduciary duty to the board that they serve on. But at the same time, there may well be a question that says, look, you're not happy, whether it's through the chair, through the CEO, this is what's going on. Because, you know, if your investment is diluted without you knowing, without the requisite checks and balances in place, there is a responsibility between the PIC and that entity, whether it's VBS or anybody else, to say what is happening here. Yeah. So did any discussion take place in the manner other than what you've indicated here about following your rights or having the rights issue and being able to look at that? But the question for me is, why did that happen in the first place, and what would that have triggered an interaction from the PIC with VBS to say what is going on here and why?
The interaction with the client after or post-investment is usually between the client and our PMV or post-monitoring division. So they are the ones who should keep contact with the client, as well as the investment team who was involved in approving the transaction. So in this instance, that is why the team had to take initiative and make sure that this thing was done as was initially intended. Or it was supposed to.
And did you interact with the post-investment team as well to express concerns and ask them to look at things?
Through you, Commissioner, yes, we did. Hence, we had Mr. Kaya Zonke and Yongama Melapi of PMV during that meeting as well.
So is it correct to say that they also didn't have joy with VBS, the people in PMV who were responsible for monitoring the investment?
Through you, Mr. Commissioner, I think there'll be a better place to respond to that question. But every time when they had issues with receiving information, they would ask for assistance from the investment team, which was majorly myself, and then I would call Mr. Truta or send him emails and remind him that he has to submit documentation to our PMV division.
Thank you. It seems like the questions have run dry.
In terms of the changes that were put into the final agreement, was that found out after the collapse of the bank, and there was something done about it?
Through you, Mr. Commissioner, I'm the one who got aware of it at that time, because the person who was responsible for the agreements or who was making sure that the agreements were signed is the legal representative, or the legal division was responsible for making sure that the agreements are signed.
Yes, once you found out what happened, was something done about it, or you just found out and kept quiet about it?
Through you, Mr. Commissioner, it was not only me that found out about it. I think it was something that was discussed at the PIC. PMV division also knew about it. And in this instance, I'm not sure of the processes that was followed to resolve or attend to that issue. I cannot talk to it because I don't know.
Just to place it on record, Mr. Commissioner, we intend to call a person from the legal division to speak to the whole question of these inserted clauses into the agreement.
Yes, thank you. Ms. Mdluli, thank you very much. Thanks for your time. And thank you for making yourself available to come and testify before the Commission. It has helped us a lot. Thank you.
Thank you, Mr. Commissioner.
Your full names are?
Sello Simon Ngwane.
Do you have any objection to taking the oath, Mr. Ngwane?
No, Commissioner.
Do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth? Raise your right hand and say, so help me God.
So help me God.
Thank you very much. You may be seated.
Mr. Kwani, you've also prepared a statement in relation to the evidence you're about to give to the Commission. Is that correct?
Yes, Commissioner.
And you were not compelled to prepare the statement or to give the statement?
No.
Nor were you compelled to insert things in your statement with which you didn't agree?
No, Commissioner.
Thank you. Let's start from paragraph 1.1 of your statement.
Thank you, Commissioner. I, Sello Simon Ngwane, a South African national, confirm that I reside at Pretoria, South Africa, and further confirm that the contents contained in this statement are true and accurate. I was employed by the Public Investment Corporations on the 2nd January 2011 and have been in its employ since then with uninterrupted service, holding the position of Operations and Investment Support Manager, which position I hold even today, reporting directly to the Executive Head Investment Management. I have been requested by the Judicial Commission of Inquiry into allegations of impropriety regarding the PIC Judicial Commission of Inquiry investigators to submit a statement which details the role and responsibilities of investment management operations, IM operations, with regard to the procurement process as it relates to the due diligence process within the listed investment, and also in relation to the role of IM operations with regard to the disbursement of the 350 million revolving credit facility approved for VBS Mutual Bank, which I'll refer to as VBS. The following section deals with the role of the investment management operations and the role of investment management operations with regard to the VBS. Investment Management Operations Division. The division falls within the Investment Management Division, or the unit falls within the division called Investment Management Division of the PIC, with its core role being to provide efficient and effective operational investment support to the investment process and teams. The investment management operation is led by myself and has a staff complement of 6 comprising of the following positions. 2 fund administrators occupied by a gentleman called Gabriel Nkale and Tsepiso Nja. Murufe Masemula, a divisional administrator, and additional 3 divisional administrators referred with the names Francina Midupi, Mpone Molai, and Khosi Tselapedi as a website administrator. The key responsibilities of investment operations includes, among other things, assisting in implementing appropriate IT systems to support the investment process, assist also to develop and implement appropriate processes, policies and frameworks to ensure seamless execution of unlisted investment activities. The IM operation plays a role across various aspects of the investment process, including but not limited to funding application process, due diligence through leading the appointment of service providers to conduct due diligence or any other assignment, handover process, disbursement process, whether initial or subsequent disbursement. On the corporate side, the IM operations coordinate and assist and liaise with internal and external auditors in regard to internal and external audit work within the investment divisions. The IM operation contributes and provides inputs to various monthly and quarterly reports prepared by various divisions within the PIC. Below is a key investment and other processes where IM operations is involved: unlisted investment procurement, unlisted investment disbursement process, domestic and international travel process, and management fees. I'll move to paragraph 4, which deals with the unlisted investment procurement.
Before moving on, Mr. Nkwan, can you just explain these roles that IM operations plays? Unlisted investment procurement, what does that entail?
Through you, Commissioner. So once a transaction is approved to go to DD by PMC1, then the investment team will then assess whether the due diligence would be executed by either internal capacity, using internal capacity, or appointing external advisors. So how we assist in that process is that the process of appointing the external consultant, we lead that process, we coordinate that process. That would include working together with the deal team to put together the scope for the DD. And also, once the scope is finalized, we will also run with the process of issuing the request for proposal to the various service providers, which would source from the approved database. And obviously, from submission of the proposals from the respective service providers, we'll then coordinate the process of evaluation of the proposals from the service providers, which the deal team would then focus on the technical side of it. If, for example, it's a technical DD, they will then assess or evaluate the proposal from a technical point of view, and then from our side, we'll then look at the other side of it, which is mainly administrative part of it, including the evaluation in terms of price and of course, BEE. And then we'll then run with the process of the recommended service providers for appointment or approval to appoint by the delegated official. And in terms of the disbursement process, our role is that all the initial disbursements, following the handover meeting, we will run with the process of putting together the disbursement file. And in my statement, I've actually articulated exactly what is contained in that disbursement file, which I will cover the rest of our role as I go through my statement. The investment mandate concluded between the PIC and its client makes provision for PIC to appoint third-party advisors, and costs associated with such appointment of third parties shall be for the account of the client. The client in this case I'm referring to, in our case for unlisted investment, I'm referring to the GPF, UIF, and CC. Amongst other things, the advisors can be appointed to conduct due diligence on the transaction on behalf of the PIC, particularly where the PIC does not have the necessary internal capacity to perform such due diligence. The appointment of such third parties follows and is governed by an approved assets under management procurement policy. It must be noted that the specific divisions within this apologies, Commissioner. It must be noted that specific divisions which this policy is applicable to is the private equity and SIPs and the impact investing and funds of funds, and any other division that appoints service providers where costs are incurred on behalf of the clients. The unlisted properties division has its own procurement policy and process, and accordingly not dealt with in the statement. It must be emphasized that when the PIC procures on behalf of its client, who neither are governed by the PFMA nor are organs of state, or may be subject to regulatory exemptions or exclusions, or whose investment activities are excluded or exempted, it is important to note that the provisions imposed by such government procurement legislation are not applicable to such clients. Notwithstanding such exemptions, the Unlisted Investment Division endeavors to ensure that this policy espouses the principle embedded in the government procurement legislation, such as fairness, equity, transparency, competitiveness, value for money, and risk management. The process outlined below must be read with the Unlisted Investment Delegation of Authority, the AUM procurement policy, and the procedure manual for the unlisted investments. The PIC Supply Chain Management Unit are required to confirm for any AUM procurement undertaken on behalf of the PIC clients that the approved process have been complied with. Procurement process. Once the Portfolio Management Committee Unlisted Investment, which is PMC1, has approved for a transaction to go to DD, the investment team, environmental, social, and governance team, which is referred to as ESG, legal team, and the risk team must decide which component of the due diligence will be outsourced and which component will be executed using internal resources. In case where the decision is to outsource, this process is led and coordinated by investment management operations team, except in case of legal due diligence, which is coordinated and led by the legal unit directly. It must be noted that the same policy referred to above is applicable to the procurement activities by the legal unit. This arrangement I found at the PIC when I joined. As with other AUM procurement, IM operations was and is responsible to monitor compliance with the provisions of the AUM policy and processes, and further coordinate and oversee the procurement process. I was not sure of the rationale of this separate arrangement and don't recall what explanation was provided when I raised this matter, but was comforted by the fact that the PIC Supply Chain Management Unit signed off to confirm that all due processes have been complied with all legal unit recommendation to appoint legal firms for due diligence or drafting of legal agreements. The respective teams assisted by the IM operations team will prepare requests for proposal, RFP, and such RFP will include, amongst other things, at a minimum, background of the transaction, the scope of the due diligence, evaluation criteria, timelines for submission of proposals, and other administrative requirements. Service providers with appropriate and relevant experience will be selected from an approved database. The database was established some 3 years ago and is managed and maintained by the IM operations. In terms of the AUM procurement policy, potential service providers can apply to be listed in the database at any given time by completing an application form. Once the application form is completed and the required documents attached, such will be submitted to IM operations. An administrator within the IM operations will prepare a memo for submission to myself, and after review, recommend to the Executive Head Investment Management, Ms. Rubina Solomon, who will approve the service provider for listing. Once the submission is approved, the service provider will be listed in the database. If there are no sufficient and or experienced service providers on the approved database, a request for approval to approach service providers outside the database will be prepared, and such request will be approved in line with the delegation of authority. Once the RFP is completed and the required number of service providers have been identified, whether through the approved database or outside the database, the RFP will be issued by the IM operations team to the selected service providers. The RFP will be accompanied by the declaration of interest and non-disclosure agreement to be completed by the service providers approached. Depending on the requirements of the RFP, the potential service providers will submit proposals in electronic form and or hard copies to IM operations team within the required timelines as stated in the RFP. Once received, the IM operations team will convene an evaluation task team, and the proposal will be evaluated in line with the AUM procurement policy and the RFP criteria, as outlined in line with the RFP criteria. All members of the task team are required to complete declaration of interest forms before they can participate in the evaluation process. Following the evaluation process, the service provider with the high score will be recommended for appointment. The memorandum recommending the service provider with the high score will be prepared by IM Operations. The memo must be accompanied by relevant document to support the recommendation. The approval of the recommended service will be done in line with the delegation of authority. Once the approval is obtained, the IM Operations shall notify the successful service provider formally, and also unsuccessful service providers will be notified. The IM Operations shall lead and coordinate the drafting and or review of the engagement letter between the PIC and the successful service provider. The engagement letter must also be reviewed by legal and signed in line with the delegation of authority. Once an engagement letter is signed, a kickoff meeting, which is led by the investment team, is scheduled by the operations team with the appointed service provider for a briefing on the proposed transaction and the scope of the DD. Once the appointed service provider has completed the scope of work, as outlined in the RFP, the service provider will prepare a due diligence report for submission to the investment team. The team will engage with the service provider until the final report is submitted. Depending on the terms of the engagement letter, the service provider, when submitting the final report, meaning the DD report, will include the invoice for the work done for payment purposes. The IM Operations will facilitate the approval of the invoice for payment purposes and submit accordingly the approved invoice to finance for payment. And once paid, finance will then submit a copy of the proof of payment to IM Operations team.
We move now on to the disbursement process.
Yeah, question? Yeah, question. Looking at this procurement process, especially 4.9, you know, I wonder, in general, when you put people on a database, just, you know, a few questions there is that how do you put them, you know, first thing? Second point is how do you choose among them generally, you know, and especially if someone has done work for the PIC for a while, do you drop them and choose the others, you know? How does this whole database process work? And if people are not on that database, you say it was done about 3 years ago, how do they get onto that database? So those broad general questions on how that database works.
Thank you, Commissioner. So, as I've said, Commissioner, that the database was established some 3 years ago. And as part of the policy, the procurement policy, there's a provision in the policy which allows service providers who want to list on the database to apply for listing on the database. The process of listing is that there's a form that they are required to complete. That form has a number of things in it. For example, we require that you provide us with the type of services that you provide, the directors of the company, the shareholders of the company. So there's a number of things that we require from a service provider who wants to be listed on the database. Now, in terms of the policy, any person who wants to list on the database can walk in and request an application form to complete in order to be listed on the service on the database. Further, Commissioner, through you, in terms of our policy, we've got a rotation guideline. So, and the reason why we have this rotation guidelines is to make sure that we don't have one service provider being appointed often, because you do have, that's one of the risks that we're facing, to say, you know, the one service provider can be appointed on a number of transactions. Immediately, that would then deny other service providers who are listed on a database being appointed. Hence, we have then developed that guideline in the policy in terms of rotation, so that we can give other service providers within who are listed on a database the opportunity to be also appointed to do work for PIC.
Sorry, just on that point, a question I would ask is it obligatory to follow that process? Because does it not disadvantage people who actually do perform well? so that if you've got a service provider who actually does everything that's expected, gears up to be able to ensure they deliver exactly what is required, but then you drop them because of rotation, and you might get somebody who does not perform as well, but they're filling your rotation requirement, not your skill, competence, expertise requirement. I would hope that it's not a mechanical rotation, but looking for opportunities. Certainly there should be opportunities for a range of service providers to participate. But I would be a bit concerned if it was, okay, you've done brilliantly, you're our best service provider, but your rotation time has come up, off you go, and we put in somebody who can't do the job, or even who can do the job. But you actually then have a situation where service providers have to grow and reduce and grow and reduce, and therefore you actually destroy the capacity over time. So I'm just really asking, not that one doesn't need to find ways in which you create greater opportunity, but whether it's simply a mechanical question, you've done your turn, now it's somebody else's. Thank you.
Thank you, Commissioner. The rotation, Commissioner, it's not intended to disadvantage those service providers who are performing. One of the things that we do is that for every due diligence, if we appoint a service provider to do a due diligence on a particular transaction, once the work is completed, one of the things that we do, as operations, we engage with the investment team. Because post the appointment, the service provider will be working with the investment team, just to assess the performance of that service provider. And where, for example, the view of the deal team is that that particular service provider has done a bad job, we don't stop there. What we also do is that we convene a meeting with the service provider, because sometimes if we don't do that, you're only hearing one side of the story. And for whatever reason, they could be saying that the service provider is not performing. But what we do is that we further engage with the service providers, just to also put the facts on the table based on what the deal team is saying, so that we can also hear the side of the service provider as to what so that we give both parties a chance, so that both parties can put their views on the table. And from that discussion, through you, Commissioner, we would then obviously come up with a plan in terms of how then do we assist the service provider if it's something that we are able to do in terms of that service provider being able to perform going forward. But we do give opportunity to these service providers to say the side of the story, so that we have both sides of the story, to make sure that a service provider is not blacklisted because somebody is saying he's not performing. In terms of the rotation, as I've said through you, Commissioner, it's not intended to disadvantage those service providers that are performing. But those who are not performing, they are flagged on our database, and they are flagged for example, we'll put them on hold if it's something that is continuous, the non-performance is continuous, or there's no improvements that we see from the service provider.
Is it mechanically applied, or is there space and leverage to reappoint and so on?
Yes, there is that space to reappoint.
Yeah, I think you were still trying to continue, so I think continue, because I'm interested in following up the points. Yeah, on this issue.
On the issue of
database.
Oh yeah, okay.
Like how it works.
Yeah. So as I've said, the database, anyone can walk in and apply to be listed on the database. And obviously, as I've said, that there's a form that's completed which requires a number of things. And once we're happy that the service provider meets the requirements, that service provider will go through the internal process for appointment.
Then a question, so if you got on transactions, let's say you got, what, sort of 50, 60 legal firms. I mean, there are many legal firms in the country, in Joburg in particular. Or you got advisors, transaction, advisors, there are many also, from big ones to boutiques. can it happen that you are on database for 3 or 5 years without being called to do some work?
I don't think it's possible because one of the things that we do is that when we select service providers, part of the process of trying to rotate is that when we select service providers, because our database is structured in a way that you are able to say, this service provider provides, for example, services on technical DD or financial DD. So if, for example, the RFP is for a financial DD, right? So we will then select from the database all the service providers that provides, for example, financial DD. Part of our policy is that the minimum requirements in terms of how many people you can approach, it's a minimum of 7 service providers. So you can't select below 7. Because unless, of course, in the database, we've got only, let's say, 6 service providers that provides, for example, a technical, or technical DD on mining. But when you select service providers from the database, you gotta make sure that you select, first of all the service providers that provides financial DD, which in this case there will be quite a lot of them that does service DD, financial DD. Now, as part of the whole process of selecting this, we'll say, and as part of trying to rotate, is that we will then obviously make sure that service providers that were not approached in the previous transactions, for example, they're included in that list of service providers that we will approach. In some cases, you find that we approach 15 service providers just to perform a financial DD on a transaction, just to make sure that people are given opportunities to make sure that they submit proposal to the PIC. We had in previous instances where we had service provider calling and saying, I've been listed on a PIC database and I've never been approached. And part of making sure that you don't have those kind of instances is that we make sure that in terms of the service provider that we approach, we make sure that it's a big number. It's not 3 or 4 people, 4 service providers, and those who were not approached in the previous transactions are included in the RFPs going forward.
And they can complain if they are not happy.
They can complain.
They can complain.
Yes, they can complain.
Okay. Then the one question I wanted to ask you is, and I think it has come up here, but it will probably be dealt with in the future. Do you have advisors that are sort of, one person said they got a high hit rate with the PIC, people who advise the PIC on transactions, say evaluations or whatever, that have got a so-called high hit rate? And how does that come about? Do you know about it, or is it part of your work? Or?
Through you, Commissioner, I take it when you say high hit rate, you mean they often quite get work from PIC. That's, if I understand you through you, Commissioner. I mean, we have instances where the deal team, for example, will prefer audit firms. You find instances where they prefer audit firms for financial DD. But of course, just to make sure that everyone gets an equal opportunity. If, for example, in this case, for example, if E&Y was appointed to do work on a particular transaction, as part of this process of making sure that everyone is given an equal opportunity, we are not going to include E&Y in the RFPs going forward. But yes, we do have, or previously we did have, advisors where it's like, you see this person working on this transaction, tomorrow, PMC approve another transaction, you see the same person. But as part of making sure, in the last 2-3 years, just to make sure that everyone is given equal opportunity, and also hence we had to put together this policy to make sure that everyone is given fair opportunity to pitch for anywhere from PIC. But I admit there are instances previously where you see the same person doing work for PIC.
And roughly, how big is that database? How many companies? On transactions, I think, I don't want to talk about supply chain, just on the transaction side.
Well, on the transaction, the database, I stand to be correct, but I think there are more than 50 service providers.
Okay, so it's not like hundreds and
No,
thousands
it's not like, hundreds and hundreds of service providers, but I think there are more than 50 service providers, yeah.
Yes, across the board. So it's sort of value for valuations, for legal advice, for what?
So maybe I should just correct through you, Commissioner. The 50 is excluding legal firms. The legal unit has got its own database of law firms. Sorry, as I've said in my statement, that the procurement process as it relates to legal firms is not handled by, is not coordinated by investment management operations, but by the legal unit themselves. So, yeah, the 50 is just excluding the legal. Yeah.
So it will be the normal ones like Deloitte, Ernst & Young, boutique firms, the standard banks and all that, yeah?
Well, majority of them are black-owned firms, small firms. Yes, you do have Deloitte, and audit firms, yeah.
All right, thank you, thanks.
We can proceed from paragraph 5.1 under unlisted investment disbursement process.
Yes. The disbursement process covers initial and the subsequent disbursements. The process followed for initial and subsequent disbursements are substantially the same, except on specific areas which are outlined below. It must be noted that the processes outlined below represents the current process, disbursement process. Both processes would commence post-conclusion of the legal agreements and the investment handover process. I just want to pause through you, Commissioner, on the investment handover process. Once the legal agreements are concluded, as part of our responsibility is to call what we call a handover meeting. In that handover meeting, we would invite the deal team, who are the owners of the transaction. We would invite all the internal stakeholders, for example, including legal, including ESG, including PMV. Now, the purpose of this, and my colleagues have spoken about it in the previous submissions, the purpose of this meeting is to appraise, to bring everyone on board in terms of the transaction. For example, if you remember in the investment process of that Mr. Roy Rashta articulated at the beginning of the commission, finance, for example, is part of the whole invest, because ultimately, and they come post mainly after the transaction is approved. So therefore, we call this meeting so that everyone can have the same understanding of the transaction prior to any disbursement that would happen on these transactions. And further to that, our requirement of the handover meeting is that the deal team prepare presentation, because obviously in that handover meeting you will have legal agreements and appraisal documents, and there's quite a number of documents. But just to make sure that everyone is on board, the requirement is that the deal team must put together a 2-3 slides to give background of the transaction. And that's the reason why we have it, so that everyone is on board as we now move to the disbursement process for a particular transaction.
Paragraph 5.4.
This process outlined below must be read with the unlisted investment delegation of authority, the procedure manual for unlisted investment, ESG, legal unit, risk unit, and portfolio management and valuation and finance procedure manuals. Initial disbursement process. Once the handover process is complete, the transaction will move to the disbursement process. The investment team and the IM operations team will together prepare a disbursement file. The disbursement file will be prepared in line with the disbursement checklist 1, which shall be signed off in line with the delegation of authority. The template of the disbursement checklist is attached as Annexure E1.
Just before we move on, Annexure E1 is the second final document in the annexures. Is that correct?
It's in terms of my annexure, my documents is just a document before Annexure F.
Yes, that's correct. So, apologies, Mr. Commissioner, we hadn't put a tab, but it is that document before the extract of the internal audit report.
Is it the one headed Isibaya, VBS loan, or what is it?
Facilities. Yes, Commissioner.
Yeah.
Yes. Thank you.
Can I continue? The purpose of the disbursement checklist 1 is to outline all documents that must be included in the disbursement file, which may include but not limited to the following: copies of the approving committee submissions, resolution of the approving committee, copies of the legal agreements, FICA certificate compliance document, completed declaration of interest forms. This declaration of interest form is completed by the deal team. CP satisfaction letter. Accompanying the disbursement file will be a disbursement memo requesting approval to disburse funds. This disbursement memo and the checklist 2 will be signed in line with the delegation of authority. Critical in the disbursement memo is the confirmation by the respective heads of the following. So meaning that the memo will be signed by the following executive heads. For example, in a case where for example, Roy's or impact investing transaction, Roy will then be the executive head signing off. The confirmation, so I'm on 5.8A. In respect of the executive head, the investment falls under. Such executive will confirm the following: that all approval conditions related to the investment and the drawdown conditions for the request have been met, and the client is entitled to draw from the available funds and accordingly recommend payment. In respect of the executive head risk, confirmation that all risks, excluding legal risks, identified at the approval stage are the same and no new risks have emerged as at the date of this drawdown request, and accordingly recommend payment. In respect of the executive head legal, confirmation that all legal risks identified at the approval stage are the same and no new legal risks have emerged as at the date of this drawdown request, and accordingly recommend payment. In respect of the executive head ESG, confirmation that all ESG risks identified at the approval stage are the same and no new ESG risks have emerged as at the date of this drawdown request, and accordingly recommend payment. Now, through you, Commissioner, these confirmations were introduced in March, and I'll talk to it when I come to section 6 of my statement. Were introduced in March 2016, and the reason why is that prior to this, the disbursement memo will just have, for example, under the executive heads, will just says recommend, not recommend. But the question was always that what are you recommending? What are you signing off when you sign off the disbursement memo? So what we then did, we then went through a process where we then looked at each and every executive heads to say, if you're signing the memo, what are you signing for? So that tomorrow there's no confusion as to why have you signed the memo, because then the memo was just saying recommended. And no one was actually able to articulate to exactly what are you recommending, and hence the introduction of this of these confirmations. Further confirmations will be provided by senior managers within the areas referred to above through disbursement checklist 2. The Critical in the disbursement checklist is the following confirmation by the respective senior managers reporting to the above executive heads. In respect of IM operations reporting to the executive head investment management, confirmation that 1, the signature on the drawdown utilization request matches the signature on the PIC records. 2, there is sufficient funds available from the committed funds to honor the request. 3, the bank account details included in the drawdown or utilization request matches the bank details or bank account details in the PIC records. In respect of portfolio management and valuation, reporting to the executive head investment management, confirmation that the condition relating to the current drawdown or utilization have been met and the client is entitled to the draw from the available funds. Furthermore, that there are no conditions that have emerged as at the date of the utilization or drawdown or utilization that would require PIC not to honor the current drawdown or utilization as stipulated in the legal agreements. In respect of the investment team, reporting to the executive head, either impact investing or private equity or funds of funds, confirmation that the conditions relating to the current drawdown/utilization request have been met and the client is entitled to draw from the available funds. Furthermore, that there are no risks or conditions that have emerged as at the date of the drawdown/utilization that would require PIC not to honor the current drawdown or utilization as stipulated in the legal agreements. In respect of legal advice, reporting to the executive head legal, confirmation that all legal risks identified at the approval stage are the same and no new legal risks have emerged as at the date of the utilization or drawdown, including that there is no non-compliance with the prevailing legal agreements, which would require PIC not to honor the current drawdown or utilization. The above confirmations are intended to provide the approver with assurance that all conditions have been met before funds are released, and there are no new unmitigated risks which the investment will be exposed to. Once approved, the disbursement memo and the disbursement file will be submitted to the investment finance for payment of the funds in line with the memo. Once payment is made, investment finance will forward proof of payment to IM operations team for filing in the disbursement file. Once disbursed, the transaction will move to post-investment monitoring and evaluation. Subsequent disbursement process. The IM operation team is responsible to initiate subsequent disbursements once they receive a drawdown or utilization request from the existing investee companies. These requests are mainly received from investee companies through emails. Once the IM operations team receives the drawdown request, a disbursement memo, the disbursement checklist 2 will be prepared by the IM operations and signed in line with the delegation of authority. The disbursement memo will be accompanied by the following documents: disbursement checklist 2, capital call or drawdown notice, portfolio company update, banking details confirmations, summary of the capital drawn to date, and any other any other document relevant to the call. The disbursement memo and the checklist will have the same confirmation as in case of initial disbursement by the executive heads and the senior managers, and both will be signed in line with the delegation of authority. Once approved, the memo and the related supporting document will be submitted to investment finance for payment of funds in line with the memo. Once payment is made, investment finance will forward proof of payment to IM operations team for filing. IM operations role in VBS, Mutual Bank. As outlined above, the investment team and IM...
Just a question. So in terms of your process, do you also service the listed side, or is just the unlisted side?
Through Commissioner, it's only the unlisted side.
The unlisted?
Unlisted side.
The unlisted side.
We don't service the listed side.
They have a separate team, or is it within the IM, or is completely separate?
They have a separate team. So the IM operations I'm referring to is only for unlisted side within that investment management division I referred to at the beginning.
Okay, so within that there is a separate team, but which is a listed team?
No, through you, yeah. Commissioner. So the IM operations that I'm referring to here, it's only for unlisted. I assume that the listed side have got their own operations team that does their operations. Yeah. So we don't handle the.
You are assuming you don't know.
They have their own operations.
Oh, okay, all right. Okay, thank you.
So is it a question of the Chinese wall?
As outlined above, the investment team and IM operations team will prepare the disbursement file in case of initial disbursement and also prepare subsequent disbursement. The disbursement file will be prepared in line with the checklist, disbursement checklist, which shall be signed off in line with the delegation. In respect of the role of IM operations, the unit led the preparation of the disbursement following the conclusion of the legal agreement in case of VBS. The first disbursement amount of 100 million was paid to VBS on the 31st of July 2015. The disbursement memo, both initial and subsequent, of all the drawdowns have been prepared by the fund administrator or investment analyst and recommended by myself prior to such memo being circulated to the rest of the signatories in line with the delegation of authority. Paragraph 16.3 just gives a table in terms of all the drawdowns that were made on VBS following the conclusion of the legal agreement regarding the revolving credit facility of 350 million.
Are there points of emphasis that you just want to point out in relation to that table?
I wanted just to, because this is a revolving credit facility, and in terms of the agreement, what it means is that any capital repayment repaid by VBS would become available for redraw. Now, if we look at that column called, which is column number 4, if you count from the left, or from my side it's from the left, which says is drawdown, the commissioner will note that there's an amount of 82.9 million, 82,999,559, an amount of 54,443,227, an amount of 21,709,792. These are the amounts that have been repaid at the days as outlined in the second column. For example, the 82,999,559 would have been a total capital repaid by the 8th of March 2017. And therefore, if we go to the next line under capital call number 6, on the 9th of March 2017, VBS drew 80 million from that 82,999,559, which was repaid as of the 8th of March 2017.
Is it fair to say from this table that immediately after payments, VBS would would make drawdowns, or shortly after making capital repayments?
Well, if you take, for example, the 82.9 million, that is repayment over a period of time. So what we are saying that as of the 8th of March 2017, the sum of the capital repaid by VBS amounted to 82.9, and hence, therefore, that 82.9 was available for redraw on the 9th of March 2017.
All right, thank you.
Based on the nature of the facility, which is...
Let's double check. So the 82 million, are you saying it's a breakdown of something else? This isn't a lump sum?
Yeah, it's the sum of all the capital
some
repaid,
payments which have happened before.
Up to the 8th of March 2017.
Yes, yes.
And therefore, you'll see then the capital call number 6, which was processed on the 9th of March 2017 for 80 million, was actually from that capital repaid of 82.9 as of then, because it's a revolving credit facility.
Did you follow up with the bank how they were using the money? Because it was ring-fenced and it was supposed to be used for that contract financing. Were they doing that?
So our role as it relates to this disbursement is that any disbursement, obviously, in the legal agreements, there would be conditions to any disbursement. In this case of VPS, when they drew any amount that is reflected in the table, there are a number of documents that they're supposed to provide before we can process for example, the underlying agreements in terms of the fuel supply would be part of the submissions from VBS. So we would not obviously proceed without these documents or those conditions as it relates to any disbursement that we make, without us receiving those documents, having gone through them, making sure that those are correct documents that we, as it relates to whether, once it is disbursed, whether they're actually going to use it, we don't go to that extent. Where we are, we expect that, for example, the PMV team, because they do post monitoring, post-disbursement monitoring, they will then make sure that, or they will, as part of their normal monitoring, just follow up on the disbursements that we have made. Based on the nature of the facility, which is revolving, the repaid capital becomes available for redraw, which, as at the time of the statement, VBS has drawn down 134 of the withdrawal capital of 159. Revolving credit facility review and suspension of the drawdowns.
Just before you move forward, so there's an amount total drawdown. You say the last amount total is 324 million. What's that? Is
so,
that?
Just to the total drawdown, right? Is the 350 million, the original facility. And further to that, they've drawn 134, right?
Yes,
From a total of 159 withdrawable amount, which is sitting in that column, the fourth column. So all in all, they would have drawn 484 million. If you take the original 350 million,
yes,
plus the 134 million that they have drawn from the repaid capital of 159.
Yes, yes. Yeah. Okay, so this RCF was growing. It wasn't limited to that 350 million.
Yeah, it wasn't limited to the, because remember, in terms of this facilities, that any capital that is repaid,
yes,
it becomes withdrawable. So, but you'll always make sure that you gotta get back to the 350, as my colleagues have explained. But in terms of the total amount that has been drawn, if you take into account what has been repaid and which was available for withdrawal, then you're looking at the total of 484.
Okay. Okay, so when the bank went down, what was the total amount that they owed to the PIC on this one, on the RCF?
Okay, so and I will then just talk to the capital, without including any interest, because remember they had drawn 350, right, and then they have repaid that 159, and then they withdrew from that 159 134. In essence, for me, you would then have to take the 350. And then you have to say, of that 350, they've repaid 159. And then, however, they've drawn 134 from that. So you will then take the 350, which I think will come back to the 324 that we say. 324, yeah.
Which was the total amount owed at a certain point in time.
If we look at the principal amount.
Yeah.
Yes.
This is what they went down owing the PIC.
Just on that facility.
Yeah. Okay. Okay, all right. Okay.
Sorry, why do you say just in that facility? Was there another one?
No, I was just making the point that it's on this other facility, because the other one were just equity. Yeah.
It was the equity. And was there any security packages arrangements on that one?
On that
324, if you're correct about that.
So my understanding of this that because the amount of standing was secured by the underlying fuel contracts, and I think we had session on the bank accounts of so there was underlying security on the 350, which were the fuel contracts.
Okay, so it could be that the PMV has managed to get something back, maybe?
I wouldn't want to comment on that.
Yeah. Okay, but I'm sure
I think there will be best place to.
We will know about it at some point. I'm sure.
We will provide that information, Mr. Commissioner. As we know, that the bank is in liquidation, and I think in that application, it appeared that these contracts were fabricated. So we would have, but we will get that information and place it before the Commission.
You mean the fuel contracts were fabricated?
That is correct.
Can I continue? In line with the provision of the legal agreements, which I think was clause 18.1, and discussions amongst PIC officials, which included Mr. Paul Magula, former executive head risk, and Mr. Ernest Nisani, former executive head legal, counsel, governance and compliance, the PIC commissioned a review of the facility, 1 year into the facility. This led to the suspension of any further drawdowns. I have attached as Annexure A to this statement outlining the concurrence of the revolving credit facility review and the suspensions of the drawdowns, which I personally sent to the VBS CFO, Mr. Philip Truter. The review of the facility was led by PMV, or Portfolio Management Evaluation, assisted by the transaction team. The IM operations were not involved in the review and have never had sight of the outcome of the review. However, during the resumption of the disbursements, I am 100% sure that I would have consulted with the PMV team to confirm whether we can now resume the drawdowns, and there are no adverse findings from the review. The review was commissioned after VBS had fully drawn down on the 350 million, which I think it was about 9 months into the facility. I was not aware that part of the conditions of the investment committee approval of the 350 million was that the 200 million could be disbursed, and based on the performance, the balance of 150 million can be disbursed. This condition was also not contained in the facility agreement. Following the suspension...
Sorry, can I just ask a question on that? Because this has come up a number of times already, that there seems to be a difference in the evidence provided to us by a number of statements so far. There seems to be a difference between what is agreed and then what is captured in the disbursement or the credit facility or whatever the entity is. And I would think that perhaps there needs to be somewhere along the line some review by our team as to how often did this occur in the cases that we're looking at, where there's an investment committee decision with conditions or pre-conditions or conditions precedent that are not captured in the agreement, in the legal agreement or in the facility that's granted, that creates a problem down the line where there is a gap between what is expected, what is agreed, what is approved, and what is finally concluded. And I think it would just be useful to get some kind of sense of that frequency, because this is happening far too often in the information before us. And therefore it must raise the question about what the legal team is doing to see that that see-through from the initial proposal and all the things that have been set are captured in the final document.
Thank you, Commissioner. We'll do so.
Can I continue? 6.7. Okay. Following the suspension of the drawdown, which communication was sent to VBS on the 5th of August 2016, the drawdown resumed in 2017 with a request to disburse 80 million from the withdrawable amount of 82.9 million. The confirmation of the withdrawable amount was received from the Unlisted Investment Valuation Unit within Finance. And in respect of the drawdown for 80 million, I have attached as Annexure B to the statement the email we have received from Mrs. Thembekile Maseko, an official within the Unlisted Investment Valuation Unit. Supporting the email is an amortization schedule which confirms the withdrawable amount of 82.9 million. This amortization schedule is attached as Annexure B1 to the statement.
So this Annexure B1, it's a spreadsheet, is that so?
Yeah. Yes, Commissioner.
Mr. Commissioner, confirm that it was difficult to have it printed. It's a big document, but it has been provided in electronic form to the Commission.
The drawdown notice from 80 million was received from VBS on the 15th of March 2017. The request from the VBS is attached as Annexure C to this statement. The drawdown for the 80 million was processed on the 13th of April 2017. The drawdown was approved under the new process, which is outlined below. The drawdown was signed off in line with the delegation of authority. A new drawdown template. In March 2016, we implemented a new disbursement template and enhanced the drawdown memo. The enhancements were intended to provide the approver with the assurance that all conditions have been met before funds are released, and there are no new unmitigated risks which investment will be exposed to. We have attached as Annexure D to this statement the discussion that led to the enhancement. It must be noted that VBS Capital Call 1 to 4 was not processed under the new disbursement templates. As stated above, the 80 million disbursement was done under the new disbursement template. We have attached a copy of the disbursement memo and the supporting documents related to the 80 million as Annexure E to this statement. The IM operation assumed that there were no material adverse outcome from the RCF review, as all delegated people have signed off the disbursement. Also taking into account that during the resumption of the disbursement, I'm 100% sure that I would have consulted with PMV team to confirm whether we can now resume the drawdowns, and there are no adverse findings from the review. Should there have been an adverse outcome from the review, it would have been detected by PMV and the deal team, and the disbursement for the 80 would have been put on hold.
Before we proceed, would Mr. Nesani and Mr. Magula have been involved in the process of approving this or the review of the transaction?
Through you, Commissioner, I assume you're referring to the disbursement memo.
Yes, okay. Sorry, the disbursement memo. Would they have been involved in that as assurance providers, the one being in legal and the other being in risk?
Through you, Commissioner, yes, there were signatories on the disbursement memo, both Mr. Magula and Mr. Nesani.
And how did this conflict with them being board members? Wherein we heard earlier, there couldn't be discussion with them because their fiduciary duty belonged to the board, the head of risk, the head of legal, and they're now approving the disbursement for the very board that they sit on, which they can't talk to you about. Through
Commissioner, it's a common practice within the PIC. In fact, it's not them only. There are PIC officials who are sitting on boards of investee companies, but over and above that, they would sign the disbursement, or they would sign the disbursement from those investee companies. However, in this case, or one could then raise the issue of conflict of interest. I am aware of personally on one of the transactions where one of the colleagues was sitting on a board, and in terms of the process from their side, from the investee company, when the capital call, when we received the capital call, right, it would have the signature of the same PIC official. And therefore, for my comfort, my request was that that PIC official not sign the disbursement memo, because I view that as particularly for the fact that he's even signing off the capital call from the investee company, so that we have somebody separate who's going to then sign the disbursement memo. But yes, it's a practice within PIC at this stage. There are a number of transactions that colleagues are sitting on boards, but they also sign the disbursement memo.
Have you raised that with any structures within the PIC as a conflict of interest and a practice that has real risk involved about governance? I mean, there is a contradiction between what Ms. Mdluli said earlier about not being able to talk to them, and yet they're signing off the very disbursement. And where the fiduciary duties lie and where the responsibilities lie. And I'm really just asking whether, given that you have been aware of it, was that formally raised as a point for discussion in the PIC by you or any of your colleagues, that this is a practice that needs to be reviewed?
Through you, Commissioner, I don't recall raising it formally, but I think I had discussion informally with colleagues internally. And I think the view was that there are other compensating controls, because, for example, that memo is signed by a number of people, and including for example, in case of you take VBS, for example, you have PMV signing off also on the memo, and you have also ESG, signing off on the memo. You've got risk signing on the memo. You've got legal signing on. So the view was that. Yeah,
so the question I'm raising is that I understand that you may not have raised it formally, but because other entities are co-signing does not legitimate the practice that is there. It is something, because if I see X's, just take an example, if I see that risk has signed off, okay, I'm going to rely on risk. But maybe if I'm the risk person serving on the board, can I rely on you to be saying A in this circumstance and B in that circumstance? It becomes a conflict. So the question that arises is, who do you rely on who has signed off if there is that conflict? So it's not sufficient to say that there are other people who sign off as well. You can have 21 sign-offs, but everyone relies on the one below or the one above.
Through you, Commissioner, I take the point, and I think it's something that it needs to be looked at seriously within our processes. Yeah. Revolving credit facility agreement. As stated in above, the condition of the IC approval that the 200 million be disbursed and based on the performance of the balance of 150 million can be disbursed was not included in the agreement or the RCF agreement. Furthermore,
sorry, just before you come to the second one, because I'd also ask you with that one to explain what these two additional clauses were. But in that first statement that you're making under 611, is that not a material non-inclusion? And therefore, if legal has signed off on that, how has that occurred? Because that is material, it's not immaterial. It's a very significant requirement that has not been met, but legal has signed off on the document. Who or how does that occur?
Through you, Commissioner, I agree. I agree. It's a material. I fully agree with. I think through you, Commissioner, and I think it goes back to that point of relying on other signatories. I think if you look at, for example, in terms of the legal agreements, part of our documentation in the disbursement file is CP satisfaction letter. We place heavy reliance on that CP satisfaction letter. If we receive that letter signed off by legal to say all the CPs have been met, so we place reliance on it, or on that particular letter. And I think as it relates to this, for example, this condition of by the investment committee, and it is clearly stated in the resolution. You can clearly read it from the resolution. Why it did not end up in the legal agreement? Yes, it also baffles me. But some 2 years ago, and it will take me to an XHF. Some 2 years ago, there was an audit finding relating to that specific issue of CPs not ending up in the legal agreements as approved by the committee, and one of the recommendations by the internal audit was that the respective divisions, for example, ESG, when the transaction is taken to a committee or to PMC2 for final approval, they do their independent submission. For example, also legal, they will do their own independent submission. Now, in their submission, you find that there's conditions that they would want the committee to approve on a particular transaction. Now, so what had happened was that so if the committee approves those conditions from ESG, the executive head or the executive head of ESG did not have sight to the legal agreements until it's signed. So, which then was raised by the internal auditors to say, their recommendation was that going forward, we need to have all the respective executive heads who are interested or have got interest in the transaction to also co-sign on the legal agreements, so that would then confirm that they've reviewed the legal agreements and they've made sure that those conditions that they have tabled at the committee, PMC or IC, which have been approved, they're actually incorporated into the legal agreements. But recently we had that was the recommendation of the internal audit, and it's attached as an XHF of my submission, where they have outlined all the recommendation. And my reading of the comments from the executive is that they have adopted those recommendations from the internal audit, just to mitigate one of those risks of conditions being approved by the committee but not ending up in the legal agreements. Now, whether that recommendation was fully implemented within the PIC is another question. However, what I wanted to note is that recently we went to the investment committee we're dealing with the delegation of authority for unlisted investment, and part of the recommendation of our recommendation to IC was to say all for example, in terms of the legal agreements, before the final approval of the who's going to sign the legal agreements, all these executive heads that are impacted by this transaction should sign off to say they're happy with the legal agreements, so that tomorrow you don't end up with legal agreements which don't have these conditions that have been approved by but the view at the meeting was that that could typically prolong the process, if I may use the word. The view was that it is the responsibility of the legal team, because they are drafting these legal agreements, to make sure that whatever conditions that are approved by the committee, they end up they end up in the legal agreements. And through you, Commissioner, I think for me, part of the problem is that there are instances where clearly it's an issue of, and lack of a better word, of performance, of people not doing what they're supposed to be doing. And then tomorrow coming up with processes to try to address a problem that is not necessarily created by a process, but by purely those respective divisions or officials not doing what they're supposed to do, and making sure that where you have people are not doing what they're supposed to do, proper actions are taken. And also bearing in mind that ultimately it also hinges around, what's in the balance scorecards of those various divisions. And therefore, if you don't make sure that within the balance scorecard of those respective divisions. You don't, for example, rate them in terms of amount of transactions approved, because it's relevant to what they do. The balance scorecard should be clearly, dealing with exactly what the division is supposed to be doing, rather than doing. So for me, my view was always that I think part of the problem is that in terms of when we try, where we're supposed to deal with issues, where we're supposed to deal with performance, we turn around and just create more processes, and therefore, the process become inefficient, but purely because we're not dealing with the actual issue.
Sorry, can you just give us the date of the internal audit report, because it doesn't seem to have it?
The date of the internal audit report is dated April 2018.
Thanks. If we can go back to 611. I just wanted to understand what the 2 additional clauses were.
Can I continue?
Sorry, Commissioner,
611. It says, furthermore, there were 2 additional clauses which were added to the RCF, which I did not understand.
Okay. Through you, Commissioner, these 2 clauses relate to the 3.5 and 3.6, relating to which my colleagues have here.
Can I just ask, after legal has done the contract, or drawn the contract, it doesn't go back to the level where conditions were placed. For instance, IC. The contract doesn't go to them to make sure that all those conditions are included.
No, it doesn't, Commissioner. Can I continue? As stated above, the condition of the IC approval that the 200 million be disbursed, and based on the performance, the balance of 150 can be disbursed, was not included in the RCF. Furthermore, there were 2 additional clauses which were added in the RCF, which I did not understand, which I found later after Vibes went into curatorship from one of the PIC officials.
Just to interrupt you there, do you think it was by omission, negligence, or was it intentional to have inserted those clauses? Or do you know?
I wouldn't want to comment. I wouldn't want to comment. I don't know the reason why. Why would we insert those clauses? Particularly the fact that this typically has to be part of the approval of approval conditions. So I wouldn't want to comment because I'm not sure why those clauses were. It surprised me when I saw those 2 clauses in the RC.
Perhaps we can ask the question differently. Were you in a meeting where this issue was discussed and what was said? I mean,
the issue of the 2 clauses.
Yes.
I was not in a meeting. I was just. I think I picked up following the announcement that the bank went under curatorship, and as we were talking internally. One of my colleagues raised it to say, are you aware that these are the 2 clauses that were added into? That's how I became aware of them.
But perhaps just for clarification, given that it went into curatorship and these clauses had been introduced, what was the impact as a consequence for the PIC?
Well, so when I picked up this and also the fact that the bank went into curatorship, and I clearly, in my mind, I clearly said, you know what, whatever amount that, still it's gone. That's just what came to my mind.
In the essence of it is those 2 clauses removed the protection of the PIC.
Yeah.
And created everybody else to be, whoever would be ahead of the PIC would be last in line should anything go wrong. And that was the purpose of it.
To manage the risk of conditions approved by the approving committee not filtering through to legal agreements, it was recommended by the internal audit in 2018 that the memo recommending the sign-off of final legal agreement must include the executive heads of affected divisions to agreements, amongst other recommendations. I have attached internal audit report dated April 2018, where such recommendations were made by the internal audit as Annexure F to this statement.
Thank you, Mr. Commissioner. That's Mr. Nkwane's evidence.
Through you, Commissioner, what I'm going to say, it's not part of my statement, but I thought it'd be worth mentioning. I think part of the problem, and I think it was spoken to by my previous colleagues, around the system, the IT system. My belief is that although, yes, there are improvements that we can make within our own processes, but what is lacking now is that the proper IT systems that would support our investment process. And my colleagues made reference to a number of things we are doing manually, and which creates a bit of a challenge. And some of these things that have been picked up is purely because we don't have a proper system. But it's also worth noting that we are in a process of implementing a private equity system for unlisted investment. We've went out on a tender process since last year, and we are actually in the process of implementing the project. We expect that before the end of this year, the system would be fully implemented which will help quite a lot, because as I said, as we speak right now, a number of things within the listed division is done manually. I mean, for example, application process. It's one of the problems. At this point in time, you can't really tell how many application processes have we received in the last 2-3 weeks, because we don't have proper systems to handle this. To handle the application process. So I think for me, part of the priority is to make sure that we have these IT systems being implemented. The other thing is that that I think we need to improve on is around the handover process. In the previously, the handover process just became just a meeting that lasts 5, 10, 15 minutes, and then we are done. It started to lose the essence of it, in terms of why we needed to a handover meeting. One of the things that we were discussing internally in terms of handover process is to actually invite the investee company or the sponsor to come to that meeting, so he can meet the PIC officials face to face. So it's not a handover meeting where it's just the PIC officials only, and then we're reading documents. So it will help also to put a face to the sponsors behind, and colleagues from various units can actually engage directly with the sponsors, rather than just having a meeting where, for example, it's just the PIC official. I think, lastly, Commissioner, I believe the processes, the unlisted investment process, as I've said, have evolved over a period of time. In the last 2, 3, 4, 5 years, if you compare the process now and you compare it with the process 5 years ago, 6 years ago, it has improved significantly. But I believe there are room for improvement, as highlighted with some of these findings, or as people come and give statements. In fact, lastly, I was saying to my colleagues that as part of, I think, helping the Commission coming up with a recommendation, we should probably put a submission just to give context in terms of how we evolved from 2013, 2012, up to where we are now. From whether the governance committees, whether the investment process, whatever the case may be, so that we can also help in terms of helping the Commission put together the recommendation going forward. I'd like to thank the Commissioner.
Yeah, I think so, Judge. Yeah. You're welcome. I think would like to have that. If you can sort of prepare it and give it to the team, yeah? Submit it to the team.
Thank you, Commissioner.
I take it you signed your statement?
There is an original that's been provided to the Commission, Mr. Commissioner.
Just some clarity. You got two sections in your statement. One is on procurement and the one is on disbursements. Are they linked? I mean, you know, it seems they are two separate concepts.
When I was requested to put my statement was that because if you recall the investment process from obviously receiving application until post the disbursement, with these two key components I was trying to, and as I was requested to say in the investment process, can we deal with that part where your involvement within the investment process? One of the key our key involvement is on the DD as it relates to procurement. And then one of our key involvement is as it relates to disbursement, because I needed to cover what happened on the disbursement process as it relates to VBS. So I needed to give context to the disbursement process and our involvement in the yeah.
To cover your part in the value chain.
In the value chain, yeah.
Of the whole thing.
Yeah.
Okay. No, I'm clearer now. I'm much clearer. Okay.
Yes, thank you, Mr. Ngwane.
Yes.
Yes, thank you very much, and thanks for your time, and thanks for coming to testify before us. We've learned more about your institution, the PIC, than we knew because of your evidence. But I'm excusing you now, or we are excusing you now. Be ready, though, to come back if and when you are asked to do so, to clear up certain things that we need clearance on. All right.
Thank you,
Thank you
Commissioner.
very much. You're excused.
Thank you.
Mr. Commissioner, it's now 4:15. I'm in a difficult situation. It's been a long day. I have another witness that is ready. I don't know what is the intention of the committee. Till when do you want to sit this afternoon? What we can do, I can inform the Commission that my intention was to present part of this witness evidence this afternoon and the rest after the other witness tomorrow. But I had sight of the statement of the witness that is coming tomorrow, and it would seem to me that he will finish in the morning and that we can then deal with this witness after his testimony, if that is perhaps a more acceptable situation.
So the plan was to have one witness tomorrow?
The plan was to have one witness tomorrow, but it would seem to me that he will finish in the morning, and I understood from the Commission that we can also use the afternoon tomorrow. If all is going to plan, I foresee that we should be finished by about 3 o'clock tomorrow afternoon.
By about 3 o'clock. That's fine. That's fine. So this witness can then come tomorrow sometime?
Yes.
Yes. So we'll then adjourn until tomorrow at 10?
Thank you, Mr. Commissioner.
Yeah, we can carry on until 4 o'clock tomorrow.
Thank you.
If necessary.
Thank you.
We'll adjourn.